All right, everybody. Good morning. Let's get started. So first, let me thank the Law Review for bringing us together today. This is a subject that is near and dear to my heart. I was one of the founding signatories of the Academic Freedom Alliance, and the subject of this symposium could not be more timely. When the students began organizing it last spring, they may not have realized just how prescient their theme would become. We've seen, as an example, just in this last week, the recent controversy at Texas A&M over academic speech as an example. And regardless of one's political leanings, this symposium underscores how deeply contested and deeply consequential issues of academic freedom and institutional responsibility are today. So 2 years ago, when this Law Review hosted a symposium on academic freedom and the First Amendment, the conversation was very different. Since then, the landscape has shifted in fundamental ways. Financial pressures have intensified on universities. The nature and interest in the federal branch in higher education has changed, to sort of say euphemistically, I think intensified to an astounding degree. The Department of Education is saying much different things than it did even a year ago. And I don't think it's an exaggeration to say that the fate of universities, or at least many programs in universities, hangs in the balance over disputes over federal funding for NIH grants, NSF grants, and so on. Here at Case Western, we've gone through a lot of that. We just recently renegotiated our NIH grant funding schedule. We've also been struggling, just to put it bluntly, in our response to the executive pressure on DEI-related issues, and we've seen institutional responses across the country where people have shifted away from long-standing programs. This new environment calls for renewed and serious examination, and that's really what this symposium sets out to do, and we're really proud to be hosting it here at Case Western Reserve University School of Law. I want to first thank our distinguished speakers who are joining us both in person and online, some from coming from far away. I want to thank our faculty colleagues who will be sharing their expertise, some stepping in really at very short notice. Dean Atiba Ellis and Professor Brian Adamson, and of course our moderators Jesse Hill and Dan Jaffe. They deserve special recognition for guiding the conversations today. I want to thank our organizers who have made today possible. Symposium editor Maggie McNay, our editor-in-chief Fatima El Ghazawi, and of course our Law Review faculty advisor, and also serving as Associate Dean for Faculty Development and Research, or Research and Faculty Development, Betsy Rosenblatt. And of course, behind the scenes, there are lots of folks that are working hard to put this event together. Eric Seiler in the back, Rob Combs, Laura McNally, Melanie Walker. You just can't pull off something like this without the hard work of many, many people, and we're really grateful for all of their work in helping us be together today. So most of all, I want to again recognize our students for putting this together, for thinking of this, for coming up with the right mix of speakers, for being able to adjust to challenges when things are not going perfectly and you have to scramble. Great job on all of that, and I think this is going to be a fantastic symposium. I hope that it is a model really for what universities and what law schools should be, namely creating space for difficult but vital conversations. So again, thank you so much for your time today, for being here, and I look forward to today's events.
Thank you, Dean Rose. If you do not know me, my name is Maggie McNay, and I had the honor this year of coordinating and planning this year's symposium. But it has definitely not just been me. Our Professor Rosenblatt, Fatima, our editor-in-chief, and so many more people behind the scenes have really helped me to put on this event over the past 6 to 9 months. When I first was brainstorming ideas for the symposium, I wasn't quite sure what direction we were going to go in. I just knew that a lot of things were changing, and I thought that it might be interesting to talk about some of them, such as the executive orders, specifically regarding education, because it seemed both timely and relevant to our specific situation. But who would have thought that fast forward a few months and it would have been even more timely and relevant to what's going on in the moment in the current world. So I'm really glad that it all worked out, especially with all of the last minute changes, but it has been an honor to plan all of this. But thank you.
I think the best thing to do would be for me to jump in and do some introductions. So we have 4 amazing speakers, one by Zoom, on this panel. Actually, do I have the agenda? Yes, I do. Agenda in my hand. Catherine McFarlane, Azimudi James, I got that right, yes? Okay. William Traynor and Ruth Kolker are all luminaries in this field. Catherine McFarlane will be speaking about the intersection of disability law with higher education administrative overreach. There. And I don't have anybody else's title. I think Professor Hill did, but I'm really pleased to have each of them. Catherine McFarlane is coming to us from Syracuse University, a leading expert on civil procedure, disability law, and is, as I say, disability law luminary, as our own Professor Kovo said. It's amazing you have so many disability law luminaries here, and it's not even a disability law conference. So wonderful to have her. Azimudi James is a celebrated scholar and expert on DEI. We're very honored to have her here from UNC Chapel Hill. William Traynor is coming to us from Georgetown via Zoom, because he's also speaking at another conference today and was kind enough to just make both happen, which is amazing. We're very honored to have him here talking about how Georgetown has handled challenges that have been presented to it. Ruth Kolker coming to us from Ohio State University, also an expert on disability law and constitutional law. Looking forward to hearing what each of them has to say. Thank you very much for being here. How long should I be keeping time? Will you be keeping time? You'll be keeping time. Okay. I will now cede all responsibility.
Well, good morning, everyone. Thank you so much for having me. Thank you to Case Western. This is an incredibly well-organized symposium. And it's been such a pleasure to be here during difficult times. And I think there's quite a bit of courage to organize an event like this. And I'm grateful to be able to be in conversation with such amazing scholars, both sitting next to me and on panels later this afternoon. Your work has very much shaped my own and inspired not just my research, but the trajectory of my career as well. So I'm so grateful to be here. Today I'll be examining whether disability is different in the context of higher ed DEI. And I'm going to focus in particular on whether students with disabilities receive or received support through DEI offices that was something more than just legal compliance with the reasonable accommodation mandate. And I'll talk about what that mandate is and how it functions in higher ed. So just to give you a little bit of an overview of what I'll be talking about today, I'll be locating disability in higher ed DEI, who works on such issues, where geographically on a college campus, what do they do? Then we'll step back and examine the creation of disability-focused staff and offices on college campuses. That will help us understand where we are today and how those offices have either remained the same or have evolved over time. I'll briefly talk about the legal obligations that are specific to disability and the treatment of students with disabilities in higher ed. And finally, I'll consider, in light of all of the above, how the current wave of anti-DEI sentiment, wave is putting it lightly, right, impacts disability potentially differently than it does other identities that were arguably supported by DEI offices. Okay, so let's try and locate disability in higher ed. Where exactly does it exist? Who, what, where? So the who, to the extent disability was or is still represented in DEI or elsewhere, the people generally had very specific titles, and some of them continue to have these titles. So we're looking at people who are the ADA coordinator or the Section 504 coordinator, people sometimes known as accommodations officers or resource officers. I'll talk about what those terms mean in a few slides. What were they doing? Well, for the most part, what they were doing is what they continue to do. These individuals that I just described are largely responsible for granting or denying reasonable accommodations requested by students with disabilities. In other words, ensuring compliance with federal law. Some types of people I described, accommodations officers or ADA Section 504 coordinators, are involved in programming like planning disability pride events. And given the presence of our Georgetown colleague, I have to give a shout out to Georgetown, which has a disability cultural center. What is unique about that particular program or office is that it functions independently from Georgetown's accommodations office. It's unfortunately quite rare for students with disabilities to have a space on campus that isn't devoted primarily to either the provision or denial of reasonable accommodations. So thank you, Georgetown. Another point to be made, to the extent there is a campus office labeled disability resources, it typically serves only students. That's true on my campus. And there generally isn't a similar office, a centralized place where employees with disabilities are able to find resources or perhaps even community. And then just thinking very literally, so where exactly is this disability-focused staff? Until recently, many of them existed in a physical DEI office. They might continue to exist in that space, although as we all know, especially on state school campuses, those offices are just disappearing. But disability-focused staff might also work in a student services office that has a unit dedicated exclusively to disability. So what about people with disabilities who are employees, so faculty or staff? Well, those people might have been in a DEI office. Those individuals often are located in a human resources office. And what's interesting, so on my campus, unfortunately, like many others, we just shuttered our DEI office. So what happened to the people working on disability? Well, the ones that were working on employee-focused resources, we can think of that either as a euphemism or not, they just got moved to human resources. Before there was a DEI office, the people that worked on accommodations for faculty and staff were in human resources. So we'll be thinking today about what exactly, again, did DEI mean for people with disabilities? Their titles haven't changed, the location of their offices changed, have their duties changed? I think we still need to figure that out. Okay, so a trend that I've noticed ever since DEI or DEIA offices began appearing on college campuses is that the services provided to people with disabilities under the DEI or DEIA umbrella often looked like an example that I pulled from Columbia's School of Professional Studies website. That is, to the extent that the landing page represents the services or what that particular office is intended to provide, there'll be a description of what DEI represents on a particular campus, the resources provided to the communities that are served. But when you start looking for what accessibility means, you'll see that it is the sole component devoted to services for people with disabilities. And even in DEIA, DEI spaces, all that accessibility means, or all really that people with disabilities are provided with, is the ability to ask for reasonable accommodation. So what exactly was happening for people with disabilities in these spaces? It's worth talking about a little bit more. Okay, so let's go back in time and think about the creation of disability-focused staff and offices in higher ed. So I've been studying and really enjoying the work of Andrew Lucchese and Jay Dolmage. Jay Dolmage wrote the book Academic Ableism. This portion of my presentation and paper is also inspired by Margaret Price's work and Linda Samuel's work about crib time, crib spaces. Andrew Lucchese wrote this fabulous paper looking at how there were disability services provided to veterans returning from World War II in the 1940s that expressly, meant to bring them back into a community, to give them the experience of college life, but also had this very intentional rehabilitation focus. So Lucchese he examined what was happening at the College of the City of New York, which was folded into what is now CUNY back in the 1940s. So there was this program designed for students who were recovering from military wounds, and it was highly medicalized. And in order to gain admission to this program as a veteran that was either in recovery or had permanent, what we would say now are disabilities, these students had to be subject to an examination by an entity known as the Health Guidance Board, a group of faculty, administrators, and physicians that would decide if they were injured enough to enter into the program. And then once these students arrived on campus, in addition to their regular curriculum, they had to satisfy the university's 2-year hygiene requirement through a special physical hygiene course. And then there was constant conversations between physicians and instructors. There was no confidentiality given to these disabled students' medical records. And so the way it was presented is we're all interested in the health of the student, but if you study disability law, you know that there are different models of disability. I can't think of a more medicalized version. They were literally trying to fix them and change them and rehabilitate them for whatever version of society might still be welcoming to them in the eyes of the program. So that sounds horrific, I hope, but unfortunately there are still remnants of that type of program in the way that we provide at least accommodations to students with disabilities in higher ed today. So for example, how do you get a reasonable accommodation as a student with disabilities in higher ed? You have to go to a doctor, at least one appointment. You have to fill out forms, you have to get medical documentation. Your medical records are going to your university, right? And then they're reviewed, they're scrutinized by the Disability Resources Office, who makes a determination about whether you are disabled enough to get, for example, extra time on a test. And the other aspect that always sort of bothers me but reminds me of how these systems started off in a very medicalized way. We require students with disabilities, we use the word register. You have to register for services. You have to put your name on a registry. I think we should all be a little uncomfortable with the idea of requiring a minoritized group to register and to start collecting a list of names based on identity. I've tried really hard to get my own university to drop the name registry, which suggests that as a disabled person you have to be somehow registered. And also we require people to re-register, right? You can't just do it one semester. You have to continuously certify that you are disabled enough. So I would contrast that to what was happening at Berkeley in the 1960s and 70s. So we generally focus the start of what became the independent living movement on the arrival of a person named Ed Roberts at Berkeley in 1962. Ed Roberts had polio, he had an iron lung, he fought to get admitted to UC Berkeley, and then where he was going to live became a real human rights issue and also a problem, right? Where can he reside? And so what Berkeley did was they retrofitted a floor of its campus hospital. Problematic, right? And that's where Roberts lived originally on his own, but then it became this space where other students with disabilities also were assigned. So you had a very much segregated form of living for students with disabilities. But for anyone that's a person with disabilities in this room, especially a young person with disabilities, you know how rare it is to be able to find community. So these young people started to form bonds and to organize an incredibly active group of people. So although it was a segregated living experience, it was also this amazing place where a civil rights movement really took off. The people that lived in the facility, the dormitory that Roberts was in, became known as the rolling quads, and they pop up across all kinds of civil rights movements. The individuals that met at Berkeley in the 60s and 70s. If you watch the movie Crip Camp, you know that some of these young people met at a summer camp and then ended up going to Berkeley and participated in the infamous 504 sit-ins in the 70s. One little anecdote that I love, because it's student-driven, in 1970, students received a grant of $80,000 from the Department of Education to form what was known as the Physically Disabled Students Program. And it was much more resources-based. In fact, there was one person, an assistant director, and all he did was wheelchair maintenance, which sounds a little bit mechanical, I guess, or secondary. But oh my gosh, the way that we all need help with mobility aids, that's exactly the kind of resource that makes your quality of life excellent. So fast forward to today, there are many affinity groups that exist on college campuses that are meant to create community for students with disabilities in grad schools too. There's likely a Disabled Law Students Association here. But I myself have never run into anything, and I have to take responsibility myself too, anything that approximates the kind of community, the kind of student-led community and advocacy and resource center that existed in Berkeley in the 60s and 70s. I think the model, whatever we call resources on college campuses, is still very much medicalized. Okay, let's talk a little bit about the law. First, what is a reasonable accommodation? I've been using that term a lot. Mark Weber has said that the accommodation mandate built into the laws I'm about to talk about requires changes in the way things have always been done in order to permit people with disabilities to integrate into society on a plane equal to that of others. Could be receiving extra time on a test, could mean the removal of a physical barrier in a law school's courtroom if you can't get up steps, perhaps, and I'm being a little bit silly here, but courtrooms in law schools in general, are not very physically accessible spaces. It's hard for people with mobility impairments to navigate them. Again, in higher ed, permission to attend class virtually is a pretty classic form of accommodation, reasonable accommodation. So what laws are colleges and universities governed by? If they receive federal funding, the Rehabilitation Act of 1973 and Section 504 in particular. Terminology varies a little bit. Instead of reasonable accommodation, you might see the phrase academic adjustment or reasonable modification. There are wonderfully specific higher ed regulations implementing Section 504 of the Rehabilitation Act. What I love about them is that there's great detail about the treatment of students with disabilities in the context of student housing and financial aid and non-academic services. Title II of the ADA applies to state colleges and universities. Like the Rehab Act, Section 504, there's an accommodation mandate. In other words, you have to provide reasonable accommodations to students at Title II schools, subject to certain affirmative defenses. Private colleges and universities that are not religious institutions are governed by Title III of the ADA as public. Did I just say that? Public places of public accommodation. Private colleges and universities are places of public accommodation. So in any event, if you're not governed by the ADA, you're likely governed by Section 504 because of the receipt of federal funding. Disappearing federal enforcement, the Department of Education, which enforces Section 504, 7 of their 12 regional offices have been shuttered. The DOJ can investigate Title II and Title III violations. I don't think that is a goal of the DOJ right now, unfortunately. There was a robust history of Dear Colleague letters issued by the Department of Education's Office for Civil Rights resolving administrative complaints. There aren't that many lawsuits, there's not that much case law involving students with disabilities in higher ed, probably because that's not necessarily their, when you're a student, do you think about suing your school? Do you know that that's a possibility? Do you have the money to hire a lawyer? So the regs and the Office for Civil Rights was really creating what became precedent with regard to the application of these laws. So I'll just say that if we're thinking about resources versus accommodations, I've just explained that to provide a reasonable accommodation is to follow the law. It's not to provide a resource. So if we label an accommodations officer a resource officer, we're using a name that isn't exactly a great fit. Okay, finally getting to my point. Executive orders, how are they treating disability? So to back up a little bit and go beyond higher ed, there are 2 sets of regulations implementing sections of the Rehab Act that apply to federal employees and federal contractors, and that require sort of, I'd say, a watered-down version of affirmative action, but there is some form of affirmative action written into those regulations with respect to the hiring and treatment of people with disabilities in federal employment and federal contracting. And an interesting twist here, so there was a OPM memo from February 5th, 2025, and the titles of all these memos and exec orders, you know the tone. Further guidance regarding ending DEIA offices, programs, and initiatives. And then, so if you're taking action motivated by a protected characteristic, you can't do it anymore, right? But then there's a paragraph that says, well, of course, you still have to follow the Rehab Act, and you have to provide accommodations. And then a footnote was dropped to Section 501 of the Rehab Act as an example of a law that still must be followed. So what's going on with disability? I think there's confusion. I'm so sorry, I'm going to go just a little bit over my time to wrap up my thoughts here. Section 503, which... Okay, good, thank you. Then I'll slow down maybe. Section 503 is a regulation implementing the Rehab Act that requires federal contractors to try and hit a certain percentage of disability representation with respect to who they hire to work on the contracts they get from the federal government. And so this particular regulation, the regulations implementing Section 503 are under attack. There was a notice of proposed rulemaking issued in July by the Department of Labor that asked for comment regarding the affirmative action provisions implementing that particular section. There was a lot of feedback, a lot of comments, so the comment period got extended, I think, until just a few days ago, but it looks like those provisions are under attack. What about staff titles and responsibilities? So going back to the higher ed context, because everyone was accommodations focused before and during the height of DEI, I don't think there's that much change with respect to responsibility, but if you wanted to go beyond just the legal responsibility, there's not much happening for anyone who's a member of a theoretically protected group. The impact on disability identified staff and DEI offices. So I have to say, from the perspective of a student with disability or a person with disability, we have a fraught relationship with the people that work as accommodations officers, because what we might perceive that person to be, fairly or unfairly, is the denier of a reasonable accommodation, right? And the denial of an accommodation can mean for a student with disabilities that you have to drop out of school. It's a really consequential event. So, and I think it's fair to say there aren't a tremendous number of people with disabilities that work in accommodations or work as ADA coordinators or Section 504 coordinators. So what's the impact on people with disabilities to the extent that DEI offices are getting reconfigured or simply don't exist anymore? I don't know that there's that much. The Department of Education, in theory, is still enforcing disability law. I'm now going to do a quick comparison to other identities that were theoretically protected by DEI offices, just to show you the comparative difference. Okay, so if we're thinking about executive orders and actions, one example, this order from April labeled Reforming Accreditation to Strengthen Higher Education. Okay, thank you, yes. So what identities were called out? What were accreditors supposedly doing poorly? They were committed to diversity with respect to gender, race, and ethnicity. That was one of the ABA's sins. And these memos also mentioned Title VI of the Civil Rights Act, Title IX of the Education Amendments Act, not Section 504. So what is the target of what needs to be scaled back or eliminated are the laws that were previously relied upon to protect from discrimination on the basis of gender or race, and now those laws are being, I'd say, weaponized in a different way. If you look at the agreement that Columbia entered into with the federal government, it mentions race, gender, Students for Fair Admission doesn't mention disability. Staff titles and responsibility for the identities supporting people of color, for example, in DEI, DEIA offices. Those people's jobs are just eliminated, right? So what's happening? What's the impact on people that identify with the communities that they were serving in DEI offices? I think back to 2020, and we asked so much of people of color and women of color in particular, and they stood up and started working on these contentious and challenged programs that were under attack to focus on racial justice. There was an example from Stanford a couple years ago. Tyrion Steinbeck held a position that was DEI related. There was a confrontation with Judge Kyle Duncan. She ended up resigning, and I felt like there was just, what were we doing as a community to support her? I don't think we did enough. And then finally, what's happening with respect to the Department of Education and the Office of Civil Rights with respect to some of the other identities I just mentioned that aren't disability. There's, the instructions to that department, or at least the messaging coming out of that department, is that you're going to use Title IX, use Title VI, so gender and race, to ferret out what we would have just called non-discriminatory behavior a few years ago. Maybe we can call it reverse discrimination now, but the focus of that department is not on the problems that led to the passage of our civil rights laws. And finally, I'll just say that, of course, people with disabilities have intersecting identities. It's not a good, being a person with disabilities, you're not safe right now, but maybe a little bit cynically, we can look at what was happening in those spaces, or more realistically rather than cynically, what remains, and how do we want to treat people with disabilities on college campuses beyond the law. We can't just slap on the word resources and be done with it. Thank you so much, and I so look forward to my co-panelists' remarks.
Q&A for everyone? Or oh. Okay, cool. Yeah.
Great, good morning, everyone. I want to thank the Law Review and symposium organizers for inviting me to be here today. I want to thank my co-panelists for being in conversation with me. And I'm going to talk a little today about the impact and afterlife of SFFA as manifest in a rise in reverse discrimination lawsuits and challenges. I looked at the agenda and I was delighted to be on a panel with the term equal opportunity in it, because the understandings of equal opportunity are in flux, and this is a flux that SFFA helped usher in 2023. And that flux includes a spike in reverse discrimination suits, and that's really small. It seems so big at home. Sorry about that. A spike in reverse discrimination lawsuits, a steady co-optation of the language and framework of equal protection and anti-discrimination when discussing the experiences of white people in the United States, and an offensive by this presidential administration premised on the idea that it is white people and not people of color who are suffering racial injury. The fate of DEI programs, then, is really dependent on the rise of reverse discrimination claims, because the argument is that DEI programs are reverse discrimination programs. Now, reverse discrimination claims are not new. As early as Reconstruction, for example, responses to the idea of reparations for the formerly enslaved included arguments that to do so would be to harm whites in ways that were legally cognizable. Conservative discourse on reverse discrimination, moreover, emerged forcefully during the 1970s when white plaintiffs began to repeatedly allege that their racial identity was being used to deny them opportunities from which racial minorities were exclusively benefiting. What may be new, however, is the traction this sort of framing is now getting. From the Northwestern lawsuits regarding faculty hiring, to the Fearless Fund lawsuit regarding money's use to diversify the venture capital space, to the welcoming of Afrikaners from South Africa as political refugees to the United States, it is increasingly common to talk about reverse discrimination as if it were a significant phenomenon, and scholars who write in this area really have to engage this new normal. So in this space, I argue that it is really important to think about reverse discrimination claims as racial projects. And my definition of racial projects comes from scholars and co-authors Michael Omi and Howard Wynant. And they define racial projects as the process through which human identities and social structures are racially signified, and the reciprocal ways that racial meaning becomes embedded in social structures. As they explain it, race manifests at the intersection of social structures and cultural representations. If we only think about race as structural or institutional, think laws, policies, organizations, then we miss what it means to give race meaning in the United States, right? It doesn't just operate in terms of material realities, there's symbolic meaning. But if we think about race purely as symbols, or think about it purely as cultural patterns, we miss the ways that structures and institutions make race real and give it material consequences. Racial projects then do both. They link the ideological and practical work of making and remaking our understanding of race in the United States. So racial projects can be laws, they can be social movements, they can be political initiatives, they can be cultural phenomenon. But whatever form it takes, it interprets and explains race to us. And then, based on that meaning, we organize and distribute resources along our new understandings of race. Racial projects can happen at the state level, the institutional level, the micro level, the individual level. Now, racial projects can be good or bad, and assessment is not linked to the race of the group advancing a particular project, or even what the project's stated goal is. According to Omi and Wynant, what makes a racial project racist is if it creates or reproduces structures of domination based on essentialist categories of race. We might then consider a conservative Black racial project, one opposed to race consciousness because it purportedly fosters dependency on the state. And that project might be spurred by Black people. But it doesn't mean that the goals of such a project don't reproduce structures of domination, right? And so looking at just the identity of the group advancing the project isn't sufficient. We might look at a Latino racial project that is invested in the Republican Party as led by Donald Trump. And as headed by Donald Trump, the Republican Party has been engaging in a lot of demeaning rhetoric about Latinos, including suggestions, if you remember, that like Puerto Rico is an island of trash in the Atlantic, right? It's really demeaning language about people from Latin American countries or Spanish-speaking countries. And yet, during the same decade that Trump became the face of the party, Latino support for the party grew from 29% in 2012 to 39% in 2024. Right, so how do we assess a Latino racial project that is potentially increasingly invested in the sort of racial ordering and reordering that the Republican Party, as led by Trump is advancing? Racial projects also borrow from and against each other, sometimes making complementary claims about race and sometimes making competing claims about race and racial hierarchy. So while minoritized racial projects are typically thought to be developed in response to racial projects that advance white supremacy, minoritized racial projects also speak to each other in attempts to flatten racial hierarchy or even climb racial hierarchy. In this context, we might think about the inclusion of Asian plaintiffs in the SFFA suit. Right, Asian plaintiffs were particularly useful in SFFA because the model minority myth under which Asians have to labor made them a more sympathetic plaintiff than people like Abigail Fisher. And two, the model minority stereotypes made for useful comparisons to other minority groups, right? So we have hardworking, test-acing Asians versus lazy, welfare-cheating Blacks and Latinos, right, who weren't doing well on the tests but were still getting these benefits. In this sense, an Asian racial project advancing a sort of reverse discrimination claim both sort of corrals the language of traditional civil rights rhetoric, while also trading on other racial projects that have sought to justify the location of Blacks and Latinos at the bottom of a racial hierarchy in the United States. So if that's how we understand racial projects, then I would argue that SFFA, the suit and the movement behind it, and other reverse discrimination challenges are racial projects. SFFA as a racial reverse discrimination suit was about institutions and material realities, right? So I tell you the racial projects are about symbols and patterns. They're also about institutions and material realities. So as a material reality, higher education is a valuable good, and elite education even more so. We know post-secondary education is associated with lower rates of unemployment, higher income for all racial and ethnic groups. It serves as a signaling function to employers and imparts cultural and social capital that people can use to navigate life's ups and downs. Race-conscious admissions was an attempt to try and broaden access of minority groups to this valuable resource, an attempt to extend the distribution of the resources of elite education in particular to people of color. The ultimately successful challenge to SSFA then was an attempt to redirect these resources back to white people along racial lines, right? So we are redistributing this resource according to a new meaning of race, which is framed by the idea that race-conscious admissions is discrimination. SFFA, however, was also about racial meaning, also about symbols. The rhetoric that accompanied the lawsuit and other reverse discrimination claims is always the same. We have to advance colorblindness, right? If you consider race for both benign and invidious sources is a constitutional violation. It does not matter what the goal is. To consider race anytime demeans individuals on the level that is similar to racial discrimination that was leveled against minorities in the first instance. The consideration of race is always divisive, always unnecessary, always punishes innocent whites, always rewards undeserving minorities. And in that sense, SFFA is advancing a particular narrative, a particular meaning about how race does and does not matter in the United States. According to the petitioners in the case, today's understanding of race cannot be informed by yesterday's understanding of race. According to the petitioners, the disproportionate representation of whites in elite higher education is a natural and neutral baseline, uninformed by centuries of racial subordination that has benefited whites and harmed people of color. So SFFA and the other reverse discrimination suits that are currently percolating are a racial project, maybe we might call it a white racial project, attempting to maintain racial hierarchy or reestablish a hierarchy that was being threatened by the advance of race-conscious admissions. In closing, I want to talk about the value of thinking about these movements as racial projects, right? We could describe them in this way, but so what? What does it help us do, right? Why might it be useful to think about it in this way? And I think first that thinking about these projects as racial projects and really political projects reveals that doctrine may not actually be very helpful to us, right? We might think about adjudication itself as a form of racial project. Despite the calls of equality scholars for an anti-subordination approach to anti-discrimination that obligates the state to affirmatively dismantle racial hierarchy, the court has instead insisted on an anti-classification approach to equal protection. As a result, the court has subjected both benign and invidious uses of race to the same level of judicial scrutiny. It does not matter if it's helping or hurting, it's still going to be subject to the same analysis. Under such a regime, facially neutral laws with a disparate impact on racial minorities are preserved as long as explicit discriminatory intent cannot be found, while race-conscious policies intended to address racial inequality, like the consideration of race admissions, are prohibited. So we're getting sort of race and remedy exactly backwards, right? If it has an impact on a group that hurts them, as long as you cannot find formal language, it's fine. A policy that's more forward about thinking about impact is going to be struck down. Adhering to an anti-classification approach that permits for reverse discrimination claims advances a racial project that maintains white supremacy, both symbolically and materially, while countering projects that are meant to dismantle racial hierarchy. Ultimately, then, we might think about the Supreme Court as functioning as a handmaiden to a racial project of reverse discrimination, even as it has acknowledged in other contexts that reverse discrimination claims are not always legitimate based on who brings them. And so here I'm thinking about Dynamics Land System Decline, for example, where the court heard a challenge to a collective bargaining agreement between General Dynamics and United Auto Workers that eliminated the company's obligation to provide health benefits to retired employees, with the exception of then current workers who are at least 50 years old. It was a statutory challenge, and so the court was grappling with what the statute read. But in the 6-3 opinion, rebuffing the challenges, the court highlighted the historical disadvantage to older individuals, the widespread discrimination leveled against older workers, the cost that prompt employers to prefer younger workers over older workers, and the lack of legitimate complaints regarding discrimination in favor of older workers over younger ones. So we had younger workers who were saying, hey, this is discriminatory, right? We're going to get our benefits later, but your older employees are not going to. And the court said, oh no, you can't bring a suit, right? And because we actually don't understand that there's discrimination against you, right? People prefer younger workers. You're not going to get fired as easily. We don't have legitimate complaints, and so someone can bring a suit, but it's not young people because there's actually no structure of discrimination targeted at you, right? And so the court knows how to do this, right? And you could take these arguments and think about race, right? Oh no, you can't bring a reverse discrimination suit. We do not have data that suggests a pattern of discrimination. We know employers are going to prefer white employees based on what our cultural and racial patterns are in the United States, right? So someone can challenge it, but not you. But the court has chosen not to. Right, and so the court knows how to properly analyze reverse discrimination claims, to think about when they might be legitimate, but just refuses to do so in the context of race based on a particular racial project. Right, so what does that say about the court as a space where we might get equality, right? Doctrine and adjudication might not do it for us, and thinking about these things as racial projects might make that more obvious. Second, if we acknowledge that these are projects that construct meaning, right? Part of what is going on here is we're trying to challenge and shape people's understandings of how to think about race, then we might think more intentionally about the limits of litigation and maybe even the promise of the political arena. Litigation responses to reverse discrimination might themselves be thought of as political in nature. That is, litigation is not fought to win, but it is fought to create a counter-record that exposes the racial meanings and resource distributions implicit in reverse discrimination claims. A lawsuit challenging attempts to diversity faculty demographics through race-conscious hiring is only a new and unwarranted use of race if one ignores the public and private action that work to keep faculties historically white, right? So if we bring a lawsuit and say, oh, you've been thinking about race, this is a problem, it can only be a problem if we ignore why faculties are white, so white in the first place, right? And so discovery through litigation then can be useful forum to expose those uninterrogated racial baselines. You were saying how the faculty is composed now is neutral, but in fact, it is a function of how hiring is done, preferences, networks that are used that have tilted the faculty in a particular direction. And thinking about this in the context of SFFA, for example, that litigation exposed just how much of a benefit to white people the athletics and legacy admissions provided in the admissions context. Right? People were so horrified about this that we had a conversation about abolishing legacy admissions. Right? It became, well, if we really cared about racial equality, then we wouldn't allow athletes to get in so easily. We wouldn't allow legacies to get in so easily because we see that it's benefiting white people primarily. And so that starts to change our understanding about race. In the case of faculty hiring, everything from access to developed alumni networks, spousal hiring, sometimes the creation of fellowships that allow people to bring spouses with them, legacy enrollment at elite institutions that facilitate later employment, all of that is grounded in de jure state action that ultimately develops into informal advantages that disproportionately advantage whites, and we say this is sort of natural and occurring, but actually it's a function of formal processes. So wider exposure through discovery of this reality, even if not ultimately successful in winning or staving off the challenge, might be useful to us if we start thinking about these spaces as racial projects. Finally, if we can see that the court is advancing a white racial project, then perhaps the political process is a better alternative to resolving the competing claims to resources and racial meetings that various groups are making. Legislative processes, for example, might be superior because of the nature of racial projects. There are many ways to respond to inequality, and racial projects are neither right or wrong, good or bad. The only litmus test is whether it reifies racial essentialism hierarchy. And in this new political climate, the very nature of racial hierarchy is subject to debate. So although constitutionally prohibited according to the court, which I concede, why can't the United States think about racial quotas that other countries have used at varying levels of success? These are questions that require honest assessment of the benefits and costs of initiatives. The legislative process, with its capacity for democratic representation, data collection, opinion gathering, and ultimately negotiation, might be better suited to facilitate racial projects. And so I'm suggesting we are engaging in these projects, and what we need is transparent processes to say, yes, you're going to be disadvantaged because we're working towards this goal, right? This is a group that's going to be harmed, or what is discrimination? Do we have empirical data about that? And that might not happen very well in a judicial context. Hiding behind doctrine, right, however, and refusing to acknowledge the reality of racial projects, we are unable to honestly confront and answer these moral, social, and empirical questions. Just as legislative processes allow for disparate impact under Title VII, even as disparate impact goes unacknowledged at the constitutional level, legislative processes might produce the parameters for the engagement of race in public and private settings. If the state has the ultimate obligation to address discrimination, then perhaps race-conscious initiatives could be permitted at state institutions, right, but not private institutions, right? But these are debates that we can't have because we're like, doctrine tells us exactly what to do, and we can't actually talk about what this actually means, the trade-offs, the benefits. Maybe, given the expressive concerns animating notions of liberty and speech, private institutions like Costco can consider race, right, as long as that consideration is animated by a goal of remediation or diversity. But maybe state institutions are limited or prohibited in their capacity to think about race. In yet another iteration, the state, though limited in its consideration of race, might provide market incentives and encourage private institutions to consider race in their practices, right? All variations that we might consider if we were honest that what we are doing is trading in racial projects, right? And people are winning and losing based on those projects. That's not a bad thing. That's just what we're doing. So what's the best forum for engaging that discussion? These bargains, however, cannot be struck until racial projects are acknowledged and their engagement is no longer limited just to judicial review that purports to be colorblind, but in fact just freezes racial hierarchies in place. With that, I stop and I look forward to your comments and questions afterwards. Thank you.
Is William Trainer going after me?
I think he's somewhat now.
Professor, are we going to the Zoom now?
Yes.
Thanks very much. Can you hear me?
Yes.
Very good. Well, I have to say, I'm sorry that I
Not
can't be
see
there
you.
in person. And I want to thank Case Western and the law review and my co-panelists. I'm delighted to be part of this conversation. This is a time in what we're seeing in so many areas is the administration is really trying to stop kind of other voices that can criticize it. So we're seeing that with respect to mass media and what's happened to Jimmy Kimmel, for example. We're seeing it against law firms, where law firms are essentially being attacked because of who they represent and the lawyers that they have. And we're seeing it with respect to universities. Both Columbia and Harvard, for example, are being challenged with respect to their control of their curriculum. And Columbia has, according to the White House, agreed to essentially having its curriculum monitored for range of viewpoints, and Harvard is being challenged. And it really is something very fundamental. It's that, in a democracy, it's important that institutions have voices and be able to challenge government and the government not control what they say. So, I think that's the larger issue that we're looking at. And what I'd like to focus on in my time is kind of what's happened at Georgetown and the way in which I responded. So, earlier in the spring, I was dean at Georgetown Law, and I received a letter from Ed Martin, who was the interim U.S. attorney, and he said, and I'm going to quote from him. It's come to my attention reliably that Georgetown Law continues to teach and promote DEI. This is unacceptable. I've begun an inquiry into this and would welcome your response to the following questions. First, have you eliminated all DEI from your school and its curriculum? And second, if DEI is found in your courses or teaching in any way, will you move swiftly to remove it? And then he continued, you should know that no applicant for our fellows program, our summer internship, or employment in our office who is a student or affiliated with a law school or university that continues to teach and utilize DEI will be considered. So, what the interim U.S. attorney was saying to us was, that he had to, he would decide what we taught. And if our curriculum didn't pass muster with him, if we were, in his view, teaching DEI, he would punish our students and he would punish our graduates. And I have to say, when I got the letter, my initial reaction was that this had to be a hoax. Because I couldn't believe that a federal prosecutor would send a letter like this and would be challenging law school's ability to decide what it teaches. So my first reaction was it was a hoax, and I actually talked to our counsel's office and I said, what do we do with this? I think this is somebody is perpetrating a hoax against us, because this can't be something that a federal prosecutor would say. And they convinced me that in fact this was legitimate. It was in fact something that had come from interim U.S. attorney Ed Martin. And and then the question was how we responded, how I responded as the dean of the law school. And first of all, this was obviously very serious. It was a challenge to our ability to decide what we teach. It was clearly unconstitutional. But this is also a time in which, any decision like this to challenge the administration, is something that you have to, you don't do lightly. And, particularly when you're dealing with somebody with the power of a federal prosecutor. And, with an administration that we've seen in so many areas is vindictive. So, to challenge the administration is not something you do lightly. So, I talked to actually my wife, because this is and I said, this is something that, that they're doing that's clearly unconstitutional, and it's important that we fight back. But, I want to talk to you about it because I think there's also a personal risk that's involved in fighting back. And it's something that, could affect not just me, but all of us, the entire family. And she said, you should do what's right. So what I did was, I responded to the interim U.S. attorney that, what he was doing was unconstitutional, and, we would not comply with his demand. And so I wrote a letter to him in response. And I said, it's a Catholic and Jesuit institution. Georgetown is a Catholic and Jesuit institution. We're founded on the principle that serious and sustained discourse among people of different faiths, cultures, and beliefs promotes intellectual, ethical, and spiritual understanding, and that this principle is an educational and moral imperative. And that his letter challenges our ability to define our mission as an educational institution. It inquires about Georgetown Law's curriculum and classroom teaching, asks whether DEI is part of our curriculum, asserts that you will not hire our graduates, individuals from our school, if you find our curriculum unacceptable. And that's flatly unconstitutional. That the First Amendment guarantees that the government cannot direct what Georgetown's faculty teach and how to teach it. And the Supreme Court has continually affirmed that the freedom central to the university's First Amendment rights are its ability to determine on academic grounds who may teach and what to teach. So that, that was our response. And I also talked about, kind of in addition to the First Amendment right that universities have, and the Supreme Court case law is clear that institutions have First Amendment rights. So there was the NRA decision from 2 years ago. That was the basic principle, that the NRA has First Amendment rights. And that applies to universities, and that is longstanding. It goes back to Justice Frankfurter's decision in Sweezy versus New Hampshire, which is 60 years ago. It's been reaffirmed by the Supreme Court. And it's really, it's a vital principle in a democracy, that universities should be able to teach what their mission directs that they teach. And I also talked about how, we're a religious institution, we're a religious and Catholic institution, that listening to all the voices, empowering everyone, is part of our mission. That kind of educational discourse among people from different backgrounds and perspectives is part of our mission. And so what he was doing and challenging that was not just challenging free speech rights, but was also challenging religious freedom. And so again, I think the Supreme Court, the School of Guadalupe decision stands for the proposition that religious schools can decide how they operate, what their pedagogy is, based on their mission. So, it was a challenge both to the university's free speech rights and to religious institutions' religious freedom, and it was very direct, and that we would not comply. So that I would get a response, that would range across the spectrum. That some people would be supportive, and that other people would be critical of what we were doing. And I have to say, what I was really struck by was, the fact that I received kind of uniform support. I received actually a petition from 18,000 people, 18,000, who said that, identifying as Christians, they were writing to express support for what I'd done. And I have to say, I was just, when I got the petition, I was just astonished that 18,000 people from literally around the world had signed this petition. And I received support really from our most conservative alumni. Again, kind of the people who I was most hesitant about, how they would react. And it was just, kind of uniform support, again, from people across the spectrum, and literally around the world. So that was heartening. Now, the one thing that I often say about this is, the one thing that I've had mixed reactions is when I read I read my draft letter to my wife Allison. I said, this is what I want to send. Do you have any comments? And she said, it's very good, and I really like it, and you should send it, but you should call him interim U.S. attorney. You should call him interim U.S. attorney, and you should do it several times. So the one thing that frankly mixed reactions is what I hear again and again is people say to me, that was a very powerful letter. We totally agree with you. And what I really like is the way you call him interim U.S. attorney. So that's all credit to Allison, and I want to acknowledge that, but I'd also like recognition of my contributions to the letter as well. I think, one of the takeaways for me for this though is, at a time in which, what we're seeing is really an attack on, people's ability to, other institutions' ability to kind of criticize the administration and to have their own voices. The uniform positive response is something that I really want to emphasize because it's striking. I mean, I've been between Fordham and Georgetown. I was dean of 2 law schools for 23 years. And I've done a lot of things that are controversial, and I'm used to receiving positives and negatives. I've never done anything like this in which the responses I've received have been, uniformly positive. And I think that reflects the fact that, we as a society realize that this isn't something that's important to fight over. And that it's important that universities have their voice, that law firms have their voice, that media have their voice. And, this is a time, again, in which we're seeing, challenges, in so many ways to kind of crucial players in civil society, ability to use their voice. And it's also striking to me, the hesitancy that some people have about speaking out and speaking back. There was a letter that law school deans, sent, kind of telling the administration that they were violating the Constitution and attacking law firms because of who they represented and because of the lawyers they employed. That was an attack on kind of the right to counsel that's a fundamental protection of the Bill of Rights. And what I was surprised was, first of all, it was just kind of a very vanilla letter, frankly. It was just kind of straightforward and struck me as kind of uncontroversial. And it struck me how hard it was to get people to sign. That there are 200 law schools across the country, and I think we got about 60 law school deans to sign. And I talked to a lot of people about why they didn't sign. There were a range of reasons. But I think this is a point in which the stakes are so high, and it's absolutely essential to speak out and to push back and to fight. And what we're seeing right now is, I think so many institutions are trying to, where the stakes are so high and the threat are so real, trying to figure out, where they draw the line, and where they fight back. And I think one of the areas that for me that's absolutely crucial to fight back on, is on, for universities, their ability to control, what they teach. That, for example, is one of the challenges with Harvard. So the letter that the Harvard president received says, and I'm quoting, by August 2025, universities shall commission an external party which shall satisfy the federal government as to its competence and good faith to audit the student body, faculty, staff, and leadership for viewpoint diversity, such that each department, field, or teaching unit must be individually viewpoint diverse. So, kind of the attack that we had, on diversity, equity, and inclusion, at the Law Center, is part of a larger challenge that we're seeing to universities' control over what they taught, over what they teach. And the challenges that we're seeing right now to democracy in so many ways are so fundamental, and it's absolutely crucial to fight and to stand up for the values that define us as a country. The other point specifically about the challenge of religious institutions' commitment to diversity, equity, and inclusion. So for Georgetown, as a Jesuit university, the commitment to what we now call diversity and equity inclusion is historic and goes back many, many years. So for example, Georgetown, in the late 1960s started a black house. That's what the house was called then and now. Holy Cross started a black student union. When I started teaching at Fordham in 1991, I was put on a committee that was working on kind of a long-established program during the summer for students of color in preparation for the first-year curriculum. So this is something that I think the administration paints as they're responding just to a recent phenomenon, but for us it's a core commitment and very long-standing. So again, for me, what I'm defending is both the freedom of expression and religious freedom. And this is a moment in which so much is under challenge. Every day when we open newspapers, I see a new challenge. And it's important to stand up for what we believe in, for what's crucial in our democracy. And what I saw at Georgetown is that people are very supportive in a way that I had not anticipated or thought possible. So, this is a time in which, I can't emphasize, and I repeat again and again, it's very important to stand up for the values of our democracy. So thank you, and I look forward to the conversation.
Professor Kolker. A lot of the 2Ls have class, I believe, at 10:35, so there might be a lot of movement in and out around that time, so just please excuse that and be aware.
So they're not leaving the middle of my talk?
No.
Well, thank you so much for having me. Thank you, Maggie, for all the work that you've done to put this symposium together today. And it's really nice to follow the three fantastic talks that went before me, because I really want to build on a lot of what they had to say. And in some sense, I'm also going to be a bridge to this afternoon's presentation on academic freedom, which I was really looking forward to attending, but unfortunately my partner is sick back at the hotel, and I'm going to leave as soon as I'm done talking and drive us back to Columbus. Bad timing on his part. But anyway, so I'm going to be talking about academic freedom specifically in the context of SB1 in Ohio, which a lot of you are familiar with. I teach at Ohio State, and I'm going to talk about Ohio State's over-compliance with SB1, and I'm afraid I may shock you if you're not totally aware of what's going on. But picking up on William Trainor's comments, I've been thinking a lot about resistance, like what does resistance look like in this moment? And so some of what I'm also going to talk about is what I've personally been trying to do as a matter of resistance. And I hope we each can think about what we think our personal role is, because I think being silent, standing back is the one clear path we should not be taking. And, many of us have come to our ancestors came to the United States under perilous conditions, and I often think about that and what would they want me to be doing at this moment in our nation's history. And so, I just think we need to be thinking about what we want to be saying to our grandchildren someday, or great-grandchildren maybe in my case, about how we got beyond this moment and what were we particularly doing. So let me talk a little bit about what's going on in Ohio State. So my thesis is that this isn't just a moment when academic freedom is being curtailed. This is a moment when academic freedom is being curtailed in the service of an anti-DEI message. And I think we have to see the linkage between the anti-DEI movement and the restriction on academic freedom. This is not anything close to content-neutral limitations on speech. Is very targeted to a certain kind of speech that's trying to be eliminated. And so in that way, it's nice for me to follow Dean Trainor's remarks. So let me just start with an example of what that means at Ohio State. At the law school in particular, because one of my concerns is that this moment is also trying to erase history, rewrite history in ways that are also very damaging. So at the law school, like I'm sure at most law schools, we have this webpage, there's a nice highlight of our graduates and the great work they're doing. So we have this nice little webpage highlighting the work of David Roper. I don't know if any of you know David, but he's a 2019 graduate of the law school. He was the first black editor-in-chief of the Law Review. He got the university's Diversity Enhancement Award when he was editor-in-chief of the Law Review because he really worked to diversify the Law Review staff in terms of its racial profile. And he also was a really active member of our BALSA chapter. And so there used to be this thing that used to say actually what David did. But then the university came up with what I would call a banned words list. And they said we were no longer allowed to use certain words on our website. And so they then rewrote the website and still mentioned that he got the Diversity Enhancement Award in 2019. But then when they said why he got it, they changed it. And they said that he got it for making the journal, quote, an atmosphere where everyone felt welcome and heard. That's really different than working affirmatively to bring more Black and Latino students onto the law journal. Those are not the same things. And so they've done this repeatedly. A friend of mine runs a program through the law school where they're working to help disadvantaged communities receive better housing resources. Really important thing to be doing. They took a quote from her on the website in which she used the word disadvantaged, and they took off the word disadvantaged because disadvantaged was on their banned word list. And they didn't even go to her and say, is it all right that we're rewriting this quote? And she fought with them, and the quote stands, rewritten, not in her words. I mean, this is really shocking. So I want to talk a little bit about what SB 1 requires and then what the law school itself, the university has done in response to SB 1. And let me just highlight one little bit of it because it also ties a little bit to what Dean Trainer just said. So the SB 1 says that a university may not consider, quote, an applicant's political or ideological views in any hiring, promotion, or admissions process or decision. One of the few statements it has on it that I would agree with, okay? That's great. But then it says that each unit has to demonstrate that it is creating intellectual diversity for course approval. Well, how can you do that if you don't know the ideological perspective of the person you've just hired? You can't do both of those things at the same time. And so they're talking on both sides of their mouth because they actually don't mean right that they want intellectual diversity. They mean they want more conservatives. But you're not supposed to, you have to pretend that you're not hiring people because they're conservative, when in fact that's exactly what's happening. And not just at Ohio State, but around the country. Those of us who have friends who would describe themselves as conservative could probably tell you all the schools that are right now approaching them for some really fancy jobs that they never before were being considered for. So that's just happening nationally, not just at Ohio State. Okay, so let me tell you just a little bit about SB 1. Let me keep track of the time here. For those of you who have followed SB 1, it does all sorts of things like insist that undergraduate faculty have to post their syllabus on a central website that anybody can look at. That website has to list the professor's qualifications, their contact information, their course schedule. And, this is harassment, right? This is just an opportunity for right-wing people to find out what's in our syllabus and then to try to figure out where our classes are being held, to go harass us. And it only applies to undergraduate faculty. I feel really fortunate about that, but that's clearly very, very troubling, and we know exactly why they did that. And then they have rules, but we can't have any SB, we can't have any DEI programs. All sorts of programs, of course, have been shuttered. They describe how faculty salaries should be determined, and student evaluations have to be at least 25% of the evaluation, and that all student evaluation forms have to have the question, does the faculty member create a classroom atmosphere free of political, racial, gender, and religious bias? Whatever that means. And so, my colleagues are really quite concerned. What is this going to mean? What are students going to say? This is anonymous, right? Students can say whatever they want. And then there's a list of what are called controversial beliefs or policies. and faculty and staff must allow and encourage students to reach their own conclusions about all controversial beliefs or policies and shall not seek to indoctrinate any social, political, or religious point of view. So what's a controversial belief or policy? In case you didn't know, they include issues such as climate change, electoral politics, foreign policy, diversity, equity, and inclusion programs, immigration policy, marriage, or abortion. And therefore, and what does it mean to indoctrinate? I mean, I don't know what that means. Probably every time I open my mouth, I violate all those rules. And then we're not allowed to have diversity statements as part of the hiring process. We can't have orientation programs regarding diversity, equity, inclusion. You're all familiar with that. Okay. That's not well and good, but it gets worse. So Ohio State rushed to implement SB1 even before it went into effect. In June 2025, which is a month before SB1 went into effect, they took down the LGBTQ+ website. Just took it down. They explained the reason they did this is because it violated SB1. But SB1 says that everything has to be open to everybody, and the website didn't require a password. It was open to everybody. It included wellness resources that were open to anybody. But nonetheless, they said they had to just take down the whole website. And then they list on all the websites something like, Ohio State is in the process of revising websites and program materials to accurately reflect compliance with the law. While this work occurs, language preferencing with protected class or other activities may still appear in some places, but we're working, in compliance. And so I'm like, okay, what does this mean? So we happen to have a Department of Women's Gender and Sexuality Studies. That's their title, the Department of Women's Gender and Sexuality Studies. They're having a 50th anniversary celebration. So I wanted to see, what could they say who they are? And they do not use the word woman in their description of their 50th anniversary celebration. Like, wow, that's impressive. Whatever. So why would they do this? Well, so the university has come up with terms and phrases with a higher likelihood of non-compliance. And these are words and phrases that anyone running any kind of university website, university system has to take these words off of the website. This is an amazing list. We all should be proud to be on it. It includes diversity, DEI or DEIJ, equity, implicit bias, inclusion, inclusive excellence. That used to be like the catchword, right? Can't do that anymore. Racial justice, social justice, underrepresented, underprivileged, underserved. I mean, there's no way that SFFA requires us to not refer to those terms, right? Because SFFA does, so it suggests you should do that instead. Anti-racism. You can't say an event is for, intended to benefit, or especially appropriate for any of the covered categories. You can't say that people in various specific categories are encouraged to attend or apply, or especially encouraged to apply. You can't say that a program or event is intended to increase the number of individuals from a specified protected class or classes. But then they weren't satisfied. That wasn't enough. So then they decided that they needed a policy about pronouns. And so they have a new policy that says that formal options in university business operating systems for community members may not voluntarily notate preferred pronouns. Okay, I know that's like a lot of garbage words, but they're telling us that you can't use any university resource to ask someone to voluntarily disclose their pronoun. And so if you as a faculty member was used to sending a survey to students before the beginning of classes to ask them what pronoun you would like them to use, you could no longer use a university resource to do that. You can't hand out your seating chart and say to students, please indicate your preferred pronoun on the seating chart if you choose, right? Never required. That violates the pronoun policy. Incredible. They decided to ban shocking, because they said that it was defacing university property. But any of you who follow Ohio State football know that we hate Michigan, and any M on the university campus is crossed out, is X'd out. Jesse's probably surprised to see how she got for us last year. Yeah, all the M's are like way up high. It would be incredibly expensive to restore all those M's. But they don't care about defacing the M's, they care about chalk on sidewalks that if it would ever rain again, right, would wash away. And then the last thing they did is decided we could not have a land acknowledgement statement on our syllabus. I mean, talk about content specific, right? This content can't be on your syllabus. I don't know quite what the explanation for that is. It's a controversial belief that Ohio State is on the grounds of what used to be Native American territory. I mean, like Miami University of Ohio, they have a land acknowledgement statement on their university webpage, not surprisingly, because the Miami part of Miami University of Ohio is a Native American tribe, right? And so I guess at Ohio State, at least, we don't name them. I mean, as part of our university. So it's bad. So I've been thinking a lot about the pronoun policy because I'm like a real big pronoun person. And I asked about it, got confirmation, and understood that yes, I couldn't do what I like to do about pronouns. I could, if I had time, I would talk about the Merriweather versus Hardtop case from the Sixth Circuit, which is about pronouns, and would seem to indicate that as a faculty member, I do have choices about what to do about pronouns. And when I write up this for, the law review, I'm going to do some legal analysis of the pronoun policy, which I think is blatantly unconstitutional. But I just thought I'd end by sharing with you what I decided to do about this issue. Thinking a lot about resistance. Last March, I decided to retire from Ohio State University. I was 69. Turning 69 at the time. I was planning to work till my 70th birthday, but I decided to give myself an early birthday present because I didn't feel like I could continue to be involved with admissions and appointments with the horrible policies that were in place, and that I couldn't do anything as a faculty member to resist outcomes that I thought were improper. But I did tell them when I was going to retire that this coming spring, I'd like to teach a 2-credit class on academic freedom. It seemed like an appropriate thing to do. And I put together syllabus, and my faculty, colleagues, of course, approved it. And then this additional stuff came about, the pronoun policy, the land acknowledgement policy. And I started to feel that if I would teach, I would be what I would call collaborating with my oppressor, right? I would be having to either defy them and just get fired, although it's sort of hard to get fired in America, but not permitted to teach the class because I wouldn't comply with the rules, or I could challenge the rules, I could comply with the rules, no way, right? So I decided to do something different. So I wrote the following email to the administrative staff at the College of Law, and I then sent a copy to my colleagues. I posted it on Facebook, and all sorts of people have read it, which is so sweet. So I say in my email, as I just explained to Ann, that's our Dean of Students, the Dean who handles the curriculum, I've decided not to teach my spring semester class on academic freedom in light of the university's over-compliance with SB 1. I consider it my obligation under Title IX to give students an opportunity to voluntarily disclose their pronouns. I do not want to engage in sexual stereotyping by guessing their pronouns. I also have difficulty accepting that the anti-chalking policy is viewpoint neutral, as the university seems to look the other way at signs meaning deface to cross out the M. The policy against land acknowledgements also seems contrary to First Amendment values. I realize I could stay and fight these rules or seek compromises, but that's not how I wish to devote my energy right now. I'll be traveling to Cleveland on Thursday to speak about academic freedom at the Case Western Law Journal Symposium. That is a better use of my energy. Retirement is wonderful, and I'm trying to take steps that bring me joy. Teaching under the conditions imposed by the university will not bring me joy. I don't plan to be a stranger to law school. I will still come in for faculty coffees and workshops. In fact, in a week or so, I'm going to present this paper to my colleagues at a faculty workshop. Good idea, right? I do have very fond feelings for the board's community, and who knows, maybe I'll teach in the future if the university changes its policies. The best of luck as you try to manage these difficult times. I respect each of you for how you're handling this moment. Respectfully, Ruth. The final irony I'll bring to your attention is on October 3rd or so, I think. I'm going to be getting the first Emeritus Professor Award by the law school, and I will have an opportunity to speak at a ceremony that will, and in attendance in the audience will be alumni. I'm trying to figure out what to do with my 5 minutes. I'm thinking of reading the banned word list, reading my email as to why I will continue to teach. So I welcome suggestions from people when they have an opportunity. What's the best way to use those 5 minutes? So that's what I've been thinking about, and I hope each of you are thinking about, is what's the best way for us to use the 5 or 10 or 15 minutes that we find available each day to engage in resistance activity. Thank you.
Thank you for those 4 incredible presentations. Really just covered a lot of ground and very, very interesting. Yeah, I'm not a big sports person. It did take me a while to register what's going on with all the M's being crossed out on all the buildings on campus. Okay, so we have, I think, a bit of time for Q&A. Folks.
Yeah. First of all, Dean Trenner talked about the importance of diversity of thought. Bravo. Which makes me wonder about the composition of the symposium. Obviously, whoever put this together had no concern for diversity of thought. And this is, I think, one reason why higher education has come into such disrepute in the public, and also helps to explain why SB1 was, and measures in several other states have been adopted. This is a symposium about academic freedom. It's all about the measures like SB1 that are being taken now. Nothing about cancel culture. What's that? Nothing about conservative speakers never being invited, and the rare occasions when they were invited, they could be disinvited. If they managed somehow to show up, they'd be shouted down. We don't hear anything about that here. Professor Coker, you're concerned about SB1, one purpose of which is to increase diversity of thought in Ohio universities. And all the panelists are upset that the state is getting involved. Well, these are state institutions, but perhaps, Professor Coker, if people had started to think about, let's look at the faculty. We really don't have diversity of thought on this faculty. We really are one-sided. And, as Dean Trenner said, by the way, I'm glad he said diversity of thought. I don't think there's a heck of a lot of it on Georgetown's faculty. But if people had started to think about that and do something about that, the legislature would never have gotten involved. It's only because measures about academic freedom, that arose only because of cancel culture. The measures for diversity of thought, that arose only because the universities running themselves had decided that they were going to run partisan operations. And I'll also say for Professor James, several things I like to say, but I'll limit to just when you talked about racial hierarchy. You didn't mention that the SSFA case showed that the principal victims of discrimination, racial discrimination at Harvard, were Asians. So I'm trying to figure out here, so the SSFA decision is supposed to maintain a racial domination of America by Asians? What? Wait, what? How is that maintaining racial hierarchy and domination when in fact the principal beneficiaries of the decision are Asians?
Well, I'll let, I guess, whoever wants to go first respond.
I wanna, since that was addressed to me specifically, the interesting thing about SFFA was that there was evidence of discrimination against Asians very clearly. The lower court found it, the higher court acknowledged it. There was some confusion or maybe debate about the source of the discrimination, so the lower court thought that this discrimination probably potentially came from manifested like the recommendations that Asian American students were getting from their high school teachers, for example, right? So we can think about what the sources of it are. Could have also been in the screening process. The idea that these students were somehow getting muted personal index scores, right? And that might be based on discrimination against Asians, which is documented. This is not at all the first time that Asian Americans have been discriminated in the pool. They absolutely are. Okay, but there are empirical questions about where that comes from and the extent to which universities have to account for that. The bizarre thing about the Supreme Court's decision is that there's no remedy for Asian Americans, right? And we know that the only place the Supreme Court has allowed us to use race clearly is when we are remediating discrimination. So it's very interesting that Asian Americans were picked as plaintiffs, right? Sort of used to get the case going forward, because Abigail Fisher is not sympathetic, right? Like middle class white plaintiffs are not sympathetic anymore. It's like there are advantages here, you can see them, and then you're complaining about a small number of students who got in, and you're making assumptions about what they can do there. So Asian Americans are really used to catapult the case forward, and we acknowledge discrimination, and then the court completely ignores its doctrine about how to fix that. If we think there's discrimination in the pool, and there was, then the solution is more race consciousness. But instead, the court, that's the doctrine, and instead, the court completely ignores that, doesn't really discuss Asian plaintiffs at all, even in the dissent, right? The liberal justices don't focus on this, and we really see that this is actually not about when and where we find discrimination, it's about hostility to the consideration of race, and the court took its opportunity. And so, and I've talked about this at length. I'm not denying discrimination at all, but the court sort of ignores its own precedents about how to address that. But I'll let my co-panelists address some of the other things you said, but I would note that I find it striking that ideas about justice have become so politicized, right? As if the left could have a monopoly on what it means to be just. And if you were discussing things like morality, justice, equality, that must be a project of the left, as if conservatives are not concerned about those things, and we capitulate to that idea in this sort of political polarized space, and it doesn't really make any sense. I've often said, like, my conservative students deserve better leadership on that question. They deserve faculty who can come in and engage those questions for them, instead of making it like, if you're discussing justice, it has to be left, right? The right does not discuss justice. It seems bizarre to me. And then the final thing I would say is that baselines really matter here, right? So we think about diversity of thought in faculty, and we can debate whether we think they are or not. I find quite a bit of diversity. Many faculty members I don't agree with, but I respect them as intellectuals on my faculty. But there were not concerns about intellectual diversity in the, dozens and hundreds of years in which faculty were dominated by white men with particular views about how American society should operate. And it is only when we see the inclusion of women and the perspectives they might bring, and the inclusion of working class people and the perspectives they might bring, and the inclusion of people of color and the perspectives that they might bring, that all of a sudden it means we have necessarily skewed to the left, right? And these concerns about diversity
So now you're going to
were
get
not
even.
present before.
Get
And
even.
so it's not about getting even. It's about trying to think about what your unstated assumptions are, that before was neutral, but now has been skewed. When I think people would suggest that maybe before we're skewed, and now we're approaching balance, but if you were a beneficiary of skewed, right now feels imbalanced to you, although it isn't necessarily. I'll stop there.
I'd like to see it. Yeah, please.
Okay. So, I think that it's important to recognize two different kinds of viewpoint diversity, and both are important. Both are really essential. One is viewpoint diversity among faculty and among students, at an academic institution. I do think that, we can do a better job in terms of promoting diversity, but it's something that, I've been very committed to. So, for example, at Georgetown, about 10 years ago, we started a Center for the Study of the Constitution, which is really about originalism and it's designed to give, to create a forum for thought about the original understanding of the Constitution. It's run by Randy Barnett, who's kind of one of our leading faculty and really, a very strong conservative voice. And that's something that I've been very involved in supporting, fundraising for. I'm actually going to be speaking at its symposium next week next month about one of my books. I think I think one of the things that I think is crucial is about hearing all the voices, and that includes, the racial, political, ethnic, in every manner. So I think that's really crucial. One of the things that at last year's, I stepped down as dean, but I said the 2024 orientation to our students is, there are two things I want you to take away from orientation. One is that 13,000 people applied to be in these seats. The fact that you're here means that we picked you because we want to hear your voice. So it's important that you speak and that you say what's on your mind. But I think it's also important to realize that we picked everybody else in this room. We have an entry class of 600, everybody else in this room, because we picked them because we want to hear what they have to say. So the two things I want you to take out of orientation are, it's important to speak and it's important to listen. So, I think, again, viewpoint diversity is absolutely important within a university, within an institution of higher education. I think it's important that we're committed to it, and I think we could do a better job. That's the first point. The second point is, but the government shouldn't be mandating what we teach. The government shouldn't be telling us what we can or can't do. Again, this is, as I said, the case that is kind of the leading case right now for an institution's right to speak is about the NRA. You have the right to speak, across the spectrum. And what we're seeing right now, is that the government is trying to tell us they decide what our academic mission is. And, and I think it's important to fight that. As a leader of higher education, I feel that very strongly. And I also, I have to say that, as a leader of a religious institution, I feel like this is not just an attack on free speech, it's an attack on religious freedom. Because, we have values that are grounded in Jesuit pedagogy, that are based on Catholic social thought. These are values that have defined us. And, what we're seeing right now is, we're being told, no, the government gets to decide what you teach. And that is a violation of basic constitutional principles. So it's important to recognize both points about viewpoint expression.
If I could say just a little bit. When I think about the current moment and what's happening, I do think of it as a response to the success, to some modest extent, of diversity in my lifetime. When I started teaching in 1985, most of the schools that interviewed me, I would have been the second woman on their faculty. Second. Sometimes the first, but usually the second. I joined the faculty where I'd be the third because I didn't want to be the first or the second. When I was in law school at Harvard, 25% of my class was female. In law school now, as I'm around the country, more than half the students are women. There's been a lot of changes, but no faculty that I've been a part of is close to 50% women. And I remember when I was in high school, a teacher at my white suburban high school asked if we thought we were in an integrated public school. And a student raised his hand and said, yeah, because we have so-and-so and so-and-so and so-and-so. There were 800 students in my graduating class. And the teacher quite smartly said, if you can name them, you're not integrated. Well, I can name the black students in my law school class because we were not integrated. Most people knew the names of the women because we were such a distinct minority. And so we made a lot of strides. We're here on this panel. And so it's not surprising to me that we're seeing a backlash. And I think that's what we should call it. And they can disguise it as an interest in intellectual diversity, but that's not how I experience it. I experience it as an attempt to close the door that has started to open. Reason people can disagree about that, but that's my perspective. And as to whether we're fair to our students, in my 28 years of teaching, I not one time had a student on my SETs, my student evaluations, say that I was not promoting intellectual diversity in my classroom because I go out of my way to expose my students to a wide range of views. It would make no sense for me not to teach the conservatives on the Supreme Court because they are the ones in power. Of course I teach that material, and I teach it for what it is and what it says, and I try to expose it, its rawness, the full length of everything that has said. So, you know, I've had students ask me how I can do it. I mean, it's hard sometimes, but I feel a responsibility to do that. So I think that someone who hasn't been in our classroom and hasn't seen how we engage our students really has no right, in some sense, to comment on whether our classroom promotes intellectual diversity. I think the people who can say whether that's the case are the people who are sitting in that classroom. And one fun little anecdote, you know, there's a lot of discussion about whether common law, you know, should be taught by some really conservative professors. It's not fair to only have us people who don't believe in originalism teaching it, although of course I teach originalism. I have to. So this academic year at Ohio State, we have 3 seconds of con law. 2 of them are taught by people who I think would be comfortable being described as progressives. One person would be someone who would be totally comfortable describing himself as a conservative who believes in originalism. The students enrolled. We have 73 students in Section 1, 75 students in Section 2, and 16 in Section 3. Guess who is teaching Section 3? The conservative faculty member. So the students voted with their feet as to which faculty member's class they wanted to take. So I actually don't even think that it's fair to say that the students feel that they've been mistreated and not had the opportunity to have faculty member who identify with originalism, identify with conservative viewpoints. But anyway, I don't want to dominate.
I'd like to just say a couple of thoughts. So when we assume that there's no diversity of thought, it's interesting because I don't know how you know that about.
There's a good column in the Wall Street Journal last week about the partisan tilt of
they weren't
faculties.
writing about me or my panelists or Dean Traynor, and I'll tell you something that happened when I taught Con Law 2 in Idaho, and I have taught at several faculties where I wish you could be sitting next to me and ask me about my experience there. But in any event, one of my evals from Con Law 2 said something like, injects personal beliefs about abortion and has no care for the sanctity of unborn life. And I sat through a meeting with the then interim dean about my behavior in that class. And I said, and he said, what do you have to say? And I said, well, I'm a practicing Catholic. And my personal beliefs, but not the way I teach or indoctrinate my students are actually have been so well disguised that I was misread in the other direction. And then to the extent that I have, of course I do have liberal leanings, what I fear is that I overcorrect so much to avoid the kind of criticism that we're hearing today, because it can be career ending, especially when evaluations have that much power. So having existed in spaces both as a lawyer and a law professor, where I'm usually the only person representing the particular identity that I'm writing about once I transitioned into disability, and having to really I have to answer questions that people who are not disabled and saying more radical things than me don't have to confront. I'll give you an example. I need an accommodation myself at my workplace. I've been asked things like, I've read your scholarship, are you asking for what the law requires or the radical arguments you've made in your law review articles? I don't think people that don't have my identity and happen to also write about it face the same thing. So I love the reminder from Professor James about what's our baseline and what's our perception. I've existed in spaces where I've felt philosophically, ideologically lonely, and it's funny, in Simpro spaces I've been called quite conservative and I've had blog posts written about me. That struck me as odd, but I've had different labels and maybe I'm just an enigma. But I will say that when it comes to ideology and politics, as a person that belongs to privileged groups and non-privileged groups, I can read a room or the workplace I'm in based on how things like civil rights law are intermediated in personal relationships. And in legal academia is the most politically and socially conservative space I've ever existed in, to my surprise. And sir, I'm telling you my experience and you're rolling your eyes. So why can't we have an exchange about this, or why is my
I'd love to. I would say, I know others have to have a turn, but I'm very sorry that that whoever organized this did not include on the panel someone who would present opposing
I'm giving you
views.
an example of some of my conservative viewpoints and the fact that I actually am an outlier in my area of the law.
That may well be so. Again, this recent column in the Wall Street Journal, just as an example, cited several surveys of faculties showing where their ideological views lie.
Those surveys are so easy to answer, and I do think that there are colleagues that I work with who will vote Democrat, like the character in Get Out who said, I would vote for Obama again. This is what those surveys sometimes represent. Thank you for those of you who got what I was saying. It doesn't mean that you actually live and believe that civil rights and anti-discrimination matters. If you are problematic in the ways that those laws are intended to save us all from, in the way you interact with the person in front of you or the person that you're hiring or your students, you are not ideologically liberal. And those are the interactions that I care about, because it's how our students experience their education, it's how I experience this room, it's how you experience this room, right? It can't be foretold by a survey printed in the Wall Street Journal. We're smarter than that. You are, sir.
I want to see if anybody else has a question or would like to jump in. Yes, go ahead in the back.
So I know that when it comes to politics, the pendulum sort of swings back and forth. So let's say that the next administration comes in and adopts a pro-DEI position. So they come into office, and a lot of the sort of issues that we've talked about today, do you think that it would be enough for that administration to simply walk back all of the policies of the current administration to effectuate the what we would consider to be a pro-DEI position, or do you think that some additional steps would be necessary in that scenario? And if so, what would those steps be?
I think that's a great question. And what I see is some of the significant shifts now is not just new policy, I added this, I eliminated that, but a real shifting of norms. It's not clear to me that just because you get a different president, those norms are completely reinstated. A way of doing things, right? How do we respond to lower courts? How do we engage universities? To what extent do we feel like we can control universities? Those are fundamental American norms that are being shifted, and it's not clear to me that just because you get a Democratic president, right, our sense of how we engage these issues automatically shifts back. And the ways you get people invested in democracy is feel like if I do the right things and I play by the rules, there was some benefit to it for me. But if you have years of people breaking rules or breaking norms and winning by doing that, a political position is not going to snap everyone back to the norm. Instead, you do what benefits you. And I would never presume that a Democratic presidency would not have Russian intellectual.
I'll speak more specifically to issues related to disability and the presence of students with disabilities in education. So The early laws granting a free, appropriate public education to students with disabilities came about in the 1970s. So let's say it took maybe 20 years to get those students in college. Right now, I talked about higher ed, but the shuttering of Office for Civil Rights Enforcement offices across the country, so 7 of 12, means that all of the enforcement efforts that were keeping kids with disabilities in schools and getting them services through their IEPs and Section 504 plans, really just all these efforts that over the course of decades put kids who literally had to stay at home and had no education or were segregated in seats and on the path to go to college. That retrenchment, the loss of those services, is going to have a multi-generational effect. I suspect we'll see the numbers of students with disabilities drop in higher ed as the impact of the loss of services that they're experiencing now trickles up into those spaces. So we know how long it took to get those kids into higher ed. I think it's going to take time to just get them back on track, and there will be decreases in their representation for more than the duration of a presidential term.
I mean, I think it's also important to recognize, you're focusing in on specific rules. One of the things that this administration is using is really kind of really a coercive approach that's new. So kind of under previous administrations, Republican and Democratic, when the education department had issues with an institution, there was a back and forth and there was a process, and at the end there was a resolution. But it was a process. What we're seeing now, and I think it's just, it's so harmful in every way. And I think, that a future Democratic administration cannot do this, is do what, for example, we're seeing with Harvard, which is kind of all of their funding is being cut off up front in order to coerce a result. So I think, as we're focusing in on the specific rules, I think it's also important to look at the process and the procedures. And what we're seeing now is really a lack of process and procedures that really is coercion. And, that regardless of whether the rules are right or wrong, that cannot go forward. That, because that is, again, just government mandating what's taught without even going through any process to find out what's actually happening.
Let me just say one little thing. What I often say to people is, I don't see this as a moment. I think this is a transformational age. So obviously I'll care about who's the president in 4 years, as I always do. But I think that in some sense it almost doesn't matter. Transformational. And it isn't just the anti-DEI stuff, it's the anti-intellectual nature of what's going on in higher education generally. More online courses, less in-class instruction, more emphasis on AI. So I think there's a lot of different things happening at the same time, but I think that the constellation of them all is to really dramatically change what higher education needs.
Can you speak louder?
Okay, sorry. I'll speak closer to the mic. Anyway, I see this as a transformational era, and I think that's why I think of it in terms of resistance and what can we do. But I think waiting for the next election, that's going to solve problems, I think is pretty naive. And so I think each person has to decide for themselves what can they do at the ground level. But I think higher education has been transformed in a way that's probably irretrievable for so many different reasons. Pessimistic.
I think I said, yeah.
First off, thank you for being here. I think that in recent executive orders, we've seen that DEI and affirmative action has been seen more on the right as almost synonyms, or in other words, affirmative action DEI coming under the umbrella of affirmative action. I'm curious, do you think that these two ideas are distinct, and if so, what are those key distinctions that you can point to?
I'd just say one little thing about that. As Kat knows, I'm writing a piece about what the meaning of the A is in DEIA. I was thinking of next writing a piece on the meaning of the I in DEI. I mean, I think that it would be good for us to separate these concepts and not to just lump them all together. And you know, SB1 does that, just can't do DEI. But then when I was listening to our President Carter's State of the whatever Ohio address he gave, his university president, he actually used the word inclusion. And I was like, oh, but that's on your list of banned words, you know. But I actually mean that sort of seriously. Like, maybe there's going to be some pivoting back to what the word inclusion means, and maybe there'll be some way we can come together about the word inclusion means. I can't understand why you'd be against inclusion. It seems like fundamental, but it's on our banned words list.
Your question really gets to how language is used and what it's meant to symbolize or signal, right? Whose ears perk up when you use particular words. These are strategic decisions about what we're going to call things, what we're going to lump people together, how we're going to lump programs together. You know, it's interesting to think about DEI and like law school curriculums. If you're not allowed to talk about race, you're not allowed to talk about gender, you can't talk about class, and you can't talk about law. Right, and so is there any DEI in the first year curriculum? Well, are we talking about laws that impact people in different ways? Are we thinking about rape shield laws? Are we talking about I can't teach civil rights? I can't teach Title VII, right? Equal protection is about race, and so these words they're not precise. They are meant to signal something, and they can be used in different ways. That's a DEI hire. What does that mean? That means everyone look, a person of color or a woman got a job, right? That's not a good thing. It's not actually meant to signal anything about that person's actual qualifications. And so, getting into like what does it mean or is it separate is actually not the point. I think the point is, what are we signaling in the air, and how do we want people to galvanize in response by using these phrases that actually don't mean anything?
I did some research this summer about affirmative action in the context of disability, and then went pretty deep into history and looking at the origins in New Deal administrations and the work of economist Robert Weaver. And the further along historically you get, at least as Professor James was saying, the use of the terms as insult, I think, is absolutely similar. As someone who has some memory of the 90s, it feels familiar. So in this paper that I wrote over the summer, I found some great quotes from the mayor of Baltimore, Mayor Brandon Scott. So when the Francis Scott Key Bridge tragically collapsed in Baltimore, I think this was about a year and a half ago, he was labeled a DEI mayor and accused of somehow being responsible for the collapse of the bridge. And I love the way he responded. He said, when they call me a DEI mayor, we know what they want to say. And the replacement word is a racial slur, right? And I think it can, depending on the context, I think in this context, it gets close. It absolutely is standing in for a word that is socially unacceptable to say, but the vitriol and the venom remains.
Sorry, I just had another follow-up. I've always been really particular about how we think about admissions, right? And what does the word affirmative action mean? What meaning has it taken on? I prefer race-conscious admission, which is more specific about what is happening. And so again, just to emphasize your point, it's a great question that the language we use matters, and it carries much more than the technicalities of the words used.
And I think it's a very good question. DEI, goes beyond affirmative action, and I think race consciousness is the right way to put, what's happening. The approach in admissions. I think it's the right approach in admissions. But when I talk about DEI at Georgetown, it's really about kind of empowering all the voices and helping, encouraging people to talk and to feel comfortable talking. And sometimes race consciousness is part of that. But it's also kind of bringing people together. We have an interfaith advisory group that has students from all different religions, And I have to say, in the wake of October 7th, that was very important for us. That the Jewish and the Muslim law students were talking together. So again, I think affirmative action is part of making sure that all the voices are present in the room. But DEI, is about making sure that the voices are heard.
Yeah. So thanks for this. This is a really interesting panel. And I want to. There are a lot of strands. I want to pull on one that maybe people haven't talked a lot about in the discussion, which is a lot of the motivation, or at least the opportunity for state actors to exercise power here, comes from the fact that higher education institutions in America are so dependent on public funds, which is, in my view, very much a good thing that higher education institutions are very dependent on public funds. We have generated enormous amounts of knowledge that benefits our students, our faculty, and the world because of it. But there is, something that's resonant to people of a lot of different political persuasions that, well, if we're paying for this, then we ought to have a say in the content of this. And so if we're looking to like a new settlement after what's going on right now, what's the way to think about how we maintain institutional autonomy, maintain academic freedom, maintain academic institutions as independent civil society, knowledge-generating institutions that aren't controlled by the state, recognizing that they need to be funded significantly by the state? Like, how do we get to a world where we do that, both institutionally and politically?
Question. Who wants to tackle it? Who's got the answers?
Well, I guess I might distinguish between the money that institutions get from the federal government and the money that institutions get from the state government. So when I think about Ohio State as a supposed land-grant institution, which is sort of funny because the land was granted to us from, tribes who held it, but whatever. You teach at Michigan, which is obviously a state university as well. I mean, the idea that Michigan and Ohio should fund higher education because it's really good for the citizens of Ohio and Michigan seems to me to be really basic. But I also think that we have to think about the way admissions has become very exclusive. I know Ohio State's been working on letting people transfer automatically from two-year community colleges to Ohio State to get a 4-year degree. I think that's a great thing to be doing. I just read that they're even going to say that the tuition for those last 2 years might be free, that the state might pay for it. So I do think we should have more of a conversation about how to make higher education more accessible to everyone. And obviously in Ohio, that includes people from Appalachia, which I know Ohio State has always cared a lot about. Those people tend to be white. So I think at the state level, if we could do a better job of making education more accessible to literally everyone, of course that includes our students with disabilities as well, I think that would be a good move. And I think in some ways, this move towards elitism, selectivity, is contrary to that. Obviously, I'm sure Michigan's a lot harder to get into than Ohio State, but even Ohio State, I hear criticisms from alumni that how their children couldn't get in because admissions has become so selective at the undergraduate level. So I think that's a little different than the federal government's role. And you've worked for the feds more recently than I have. I haven't been working for the federal government since 1985, but I think that's a lot more complicated because that money isn't really going necessarily to universities as universities. It's going to medical centers and research institutions, and it's not really going to the university because of his role in teaching. It's going to the university because of his role in research. So I guess I think there's a different constellation of reasons for why we would do that. But I do think that one of the things we're seeing in the current moment, which seems contrary to prior constitutional law, is that they're taking a supposed concern about anti-Semitism, which of course I don't accept that that's the concern at all, but they take the supposed concern about anti-Semitism and then they say that Harvard can't have any of its federal research dollars to cure cancer or whatever else. And there used to be Supreme Court precedent about not using funding threats in that coercive way, and I'll be curious to see if we get some more case law on that. So I guess I would just distinguish between the state funding and the federal funding. I'm not sure it's the same constellation of interest in issues in both contexts, for whatever, however helpful that might be.
That's a great question. So how do we reconceptualize this if we had to do it again? I want to push back. I don't think this is what you were suggesting at all, but push back on the idea that because you pay something, you pay for it, you're like owed something in person. It's a very consumer model of education, which I want to push back on. But assuming we accept the idea that if I pay for it, I get something, then the question is, what am I getting, right? What am I paying to get? And I think, citizens of the state that are paying for higher ed, you're not paying to see your views necessarily reflected back to you. You're not paying to get a particular outcome that makes you feel good. What you're paying for, though, is maybe the obligation of the state to serve its citizens through its work, right? What is our mission? Do students have access to the resources we're developing, the knowledge creation that's happening? How does it serve the state? Like Carolina, it should be serving citizens of the state. How does the research, how does the teaching, how does the knowledge production enhance our lives? My life, I might disagree with what a faculty member is saying, but what I paid for was an opportunity for students to become a lawyer, right? To learn how to do that and to go out and serve people in our justice system, even if my particular ideologies are not reflected back to me. And so just thinking about how we think about what do you pay for? What are you paying for when you support a state institution? And I think it's more about the institution's obligations to you and less about getting to dictate what the institution is doing or getting to dictate that it gives you something that you want to see that makes you comfortable.
So I think my greatest familiarity is with the federal system. And I think the federal government should not be, in the business of promoting ideology, at all. What we have right now is, two things, there are two sources of primary, federal funds. One is it funds scientific research, and the other is, student loans. And, I think those are both very important. What we're seeing right now is that, the current administration is using those sources of revenue really to kind of coerce, changes in, what's taught. And, I think it's important to think about, are there things that can be done, with respect to kind of, making sure that, all voices are heard and, that there's a range of ideologies that are expressed at school. But that's not the role of the federal government. And, that's a huge concern that we're seeing right now is kind of a monolithic federal government is using its great power, to coerce what's taught.
It's interesting. I've had experiences at state schools, and I'm at a private institution right now, and faculty members were recently suspended, as far as I understand, following calls made by state politicians to the chancellor to complain about some of their recent social media posts. Obviously, that's too much, right? But when I worked at Idaho, there was an understanding that the dean of the law school had to have a personal relationship with either the governor or someone in the legislature, in part because funding was, at their discretion. It also meant that tenure committees had someone, there was a representative that somehow represented the state that would sit in and get to vote and write about your scholarship and your teaching and, who you were. It was uncomfortable in my case, because I wrote quite critically about the judiciary, and it happened to be a state judge who was, not pleased with the way I had written. But that's a little bit closer, I think, to some sort of meaningful participation. I actually the problem is if someone says we need independence, who is competent enough to ensure that the state voice can look at how I teach or what I write and determine if it is fair. Maybe teaching is a little bit better way to think about that. And competency is a big issue, and I think the debates about critical race theory really illustrate this, because none of the attacks on it, it's like, what are you talking about? Like, this exists in such a small area of academia and not in the way that it's being described. It doesn't exist in, elementary school libraries. So Where's the expertise? Where's the competency? How can we bring people to the table while respecting not just intellectual independence, but the way that we have been determined to be qualified to teach and to write? How can I engage in conversation with someone that I want to, but how can we ever be talking about the same thing is what I worry about right now. I think it should be possible, it could be possible. I haven't had an opportunity for it yet in the various institutions I've worked at.
Thank you. Please join me in thanking our panelists and our great discussion. I think there's a break now until
Now. Hey, let's all come back and convene.
You think they're the same? You think they're distinct? I didn't hear you. Yeah. But they're two
Okay, we are gonna gather up and convene.
I didn't apply to him because he did apply.
That's what I mean.
Well, like, I think we should know about like executive orders. I think it was really Oh, yeah. I think that, like, I'm gonna make the argument that it doesn't, but I just really don't think it's more argument. Well, yeah, because he can. So I'm doing like, I'm a joint Here's my argument for like why it's not, and then I'm just dropping the whole thing and going to Barbara. I feel like
Right. Okay, that's what I was thinking.
All right. We're coming together. So just to kind of bring together where we've been and where we're going, I think the last panel, and particularly the Q&A in that last panel, really brought us to the crux of the matter, which is, what is the role of government in all of this? Right? We can have a lot of questions about what makes sense to teach, what faculty should do, what the makeup of a faculty should be, what the atmosphere on a campus should be. But what we're really asking here is, what is the role of a government, of an executive power, and the administration that surrounds it in controlling all of those things? And that's very different from some of the questions that I think might have been starting to float around. Right? There are things you can't say as a matter of law, and there are things you don't feel comfortable saying, and those may be different. And something that's happening now that feels really different from what's happened in the pathway of time that's led up to now is the intervention of law in these questions of what you can and can't do as an institution of higher learning. And so we heard from William Traynor, we heard from Ruth Kolker about the very specific intervention of government and about how that intervention has caused what may be an overreaction, maybe a sort of threat response, and we've seen that on our own campus. We've seen that on a lot of campuses, that we're in an atmosphere of reactivity to the actions of an executive, and I think part of what's happening now is easy to make the observation that critique of this administration and of the political movement behind it is legally risky in a way that may not have been true in previous times. That there's a governmental force to these conversations that wasn't there, and that there's a Venn diagram that's connecting this with racialized and gendered and questions of disability matters. And that the driving force behind this is the executive branch. Here to expound upon that is Brian Adamson, who has until recently been the associate dean for DEI at this institution. And I say until recently for two reasons. One, he was already planning to come back to the faculty before his title precipitously changed. But we live in a time where his title precipitously changed shortly before he rejoined the faculty as a regular professor. And he's thought a lot about these questions and about the role of government in how universities approach these dilemmas. He is a very distinguished professor, having returned to Case, his alma mater, after 18 years at University of Seattle School of Law, or Seattle University School of Law. We are very, very happy to have him back here as an august scholar and outstanding colleague. Take it away.
Thank you, Dean Rosenblatt. Thank you all for being here, and thank you to Law Review members and staff for putting together this program. It's very, of course, timely and challenging topic because we are living in challenging times. I have a move to
keyboard.
Here we are. So, as Professor Rosenblatt alluded to, I'd like to spend maybe 30 minutes discussing the constitutional legal parameters of what is happening now with regards to the executive orders, the Dear Colleague letters, and how they have impacted higher education, particularly over the last 8 months. So we know that around February 14th of this year, United States Department of Education published a Dear Colleague letter. And that letter explained the new administration's positions with respect to diversity, equity, and inclusion, or DE&I, on those principles, and federal anti-discrimination law. Now, a few weeks after that letter was issued, there was an announcement made by the DOE that it would require states and school districts, as well as universities like ours, to affirmatively certify their compliance with the DOE's interpretation of Title VI of the Civil Rights Act, as well as Students for Fair Admissions versus Harvard, within 10 days of that letter. And the question became whether or not these executive orders and the Dear Colleague letter, whether or not those merely restated existing law, or if they created new law that was required to be complied with. So we have these executive orders. The executive order regarding ending illegal discrimination and restoring merit-based opportunity. Here are a few passages from it. Right. The gist of it is this order touches on higher education through multiple means. Right. The order directs the head of each federal agency to include in every grant award, quote, a term requiring such recipient to certify that it does not operate any programs promoting DE&I that violate any federal or any applicable federal anti-discrimination laws. And then later, as a way to encourage the private sector and institutions of higher education to end illegal DE&I discrimination and preferences, the order requires agency heads to submit a report containing recommendations for enforcing civil rights laws and taking other appropriate measures. agency heads must propose a strategic enforcement plan to deter DE&I programs or principles that constitute illegal discrimination or preferences, and it identifies up to 9 targets for examination. One of the second relevant executive orders that were signed by President Trump shortly after he was sworn into office is the executive order titled Ending Radical and Wasteful Government DE&I Programs and Preferences. Not a Freudian slip, I think, right? This order here directs the head of each federal agency, the Attorney General, and directors of the Office of Management and Budget to terminate, and it also applies to the Office of Personnel Management as well, to terminate to the maximum extent allowed by law all equity action plans, equity actions, initiatives, programs, equity-related grants or contracts, and all DE&I or DEIA performance requirements for employees, contractors, or grantees. This would include certain things like cultural competence training, et cetera, for employees or public-facing staff members or employees, for example. This executive order directed agencies to recommend actions to align agency or department grants with the policy of equal dignity and respect, or in DE&I's, this is a quote here, DE&I's infiltration of the federal government. And then the third relevant EO that was signed in January specifically addressed issues of anti-Semitism that had really come to a head after the October 7th attacks in Israel. And in response to that, the Department of Education officials and employees of the Office of Civil Rights were told that they would be expected to prioritize anti-Semitic actions or allegations of anti-Semitic activity on campuses over other civil rights cases. So in February, you then have this Dear Colleague letter, right? This Dear Colleague letter, as I said, was issued on February 14th of 2025, right? And it further advises, once again, that 14 days thereafter, the Office of Civil Rights would take appropriate measures to assess and to ensure compliance with it, right? So that's the context of all of this, right? So two things up front, right? Executive orders are not law, right? Those do not have the force of law. An executive order is a written directive signed by the president that orders the government to take specific actions to ensure that the laws be faithfully executed. And that might mean, like it's done in this case, telling the Department of Education to implement a certain rule or declare a new policy priority. Executive orders, however, cannot override federal laws, nor are Dear Colleague letters, right? Dear Colleague letters signal or give advice or give notice about how the agency interprets existing law. And that is critically important in this context, how it interprets existing law, because that is the core debate that we're seeing in the courts that are challenging this Dear Colleague letter by various organizations and individuals as plaintiffs. So what the Trump administration has done is sort of leveraged by two approaches ways to ensure compliance, right? Through enforcement actions and certifications, I should say three, and termination directives, right? To ensure that these executive orders, and by extension the Dear Colleague letters, as enforced, are complied with under the pain of termination of certain benefits, such as grants, for example, or worse, litigation and lawsuits by the federal government against institutions. So we saw in response, however, the responses of universities, for example, sort of took maybe three avenues, right? Someone would say, I would say, like ours, there was anticipatory compliance without awaiting any prompting directly from the administration. Our university scrubbed every reference to diversity from its websites, even at least initially, going so far as to, if there were black faces, some of our black alumni who were presented on our websites were gone. Right? They walked that back after they knew or realized how absurd some of the things that they were doing were, right? Others lay low, they just sit back in the cut and just watch everything go on around them, right? Other universities have done that, right? The others, like Harvard, fight, right? So those were the three tacks, right? And by my count, according to a website called Just Security, about 18 lawsuits have been filed against the Trump administration on the grounds of this DE&I, this Dear Colleague letter, and what's flowing from it. And so what I want to do with my remainder of my time is spend some time talking about what's happening and kind of my position or reasoning why I think that what they're doing is unconstitutional, as well as violative of the Administrative Procedure Act. Right? I come at this as a civil proceduralist. I know some about the Administrative Procedure Act just by virtue of my teaching mass media law and policy, where we have to engage and interface with these issues, or my students and I, quite often with regards to administrative rules and administrative compliance and the Federal Communications Commission, right? So, and then want to talk to you about prescriptions if we have time. I have several prescriptions, but we may not have time to go through them all one by one, but there are a few I just would want to highlight, all right? So, here we go. So, the APA, right, the Administrative Procedure Act, right, basically under Section 704, Title 5 of the APA, that allows judicial review of, quote, any final agency action for which there's no adequate remedy in a court, end quote. Right? So this tees up the very first legal question that we have to ask in this inquiry. So, is what the DOJ, Office of Civil Rights, is what they're doing with this Dear Colleague letter of final agency action. Right? An agency action that purports to impose legally binding obligations or prohibitions on regulated parties, and that would be the basis for an enforcement action for violations of those obligations, is tantamount to a legislative rule as well, right? To say it similarly, an agency action that sets forth legally binding requirements is a legislative rule. And so, in answering the affirmative, implying the facts to that rule, it can be shown that the OCR and the DOJ is applying and implementing this Dear Colleague letter as if it is law, as if it is a legal rule that must be complied with. And we'll get into some details and some examples later. Right? This letter is not just hortatory or tentative or interlocutory in nature. It commands, it requires, it orders, it dictates, it sets forth the agency position on these particular issues, right? And before certain actions occurred in court, the Department of Education itself was applying the letter as if it were binding, right? It referenced the letter as a basis, for example, of its investigation of 51 different colleges, right? It continued to use the letter as enforceable via the FAQs that are part of the updated Dear Colleague letter. It refers citizens to the DEI portal where they can, anyone who feels that there's a violation, a real perceived violation of the Dear Colleague letter, can file complaints, lodge complaints, right, et cetera, et cetera, et cetera. Most importantly, though, the letter's directives are changes from prior law, and they sound binding. For example, so Title VI and the SFFA decision, Supreme Court, right, has never, ever been interpreted to preclude teaching about concepts related to race. They've never been interpreted like that, right? The administration, for example, in this case, they could have said, and was perhaps trying to say, right, some type of guidance that simply clarified its position or its thoughts or its intent, for example, to prioritize Title VI prosecutions in favor of majority people. It could have said that, right? Or that it was going to intend to apply to against discrimination against all groups, even those in the majority. It could have said all of that. But it went much farther than that by expanding the definitions of stereotyping, by expanding the definitions of stigmatizing, by expanding the definition of discrimination to reach entirely new areas of conduct, right? And it did so in a way that seems legally binding, right? And as I said, just to reiterate, that it seems like a statute, it seems like a rule or a law or a legislative law, legislative rule, because it seems to supplement a statute or adopt new positions that were not existing before, effectively, February 14th, right? Also, looking like a final rule or final act is this certification requirement that's part of the Dear Colleague letter. Certification requirement requires, as I mentioned earlier, requires institutions such as ours to certify, to swear under pain of litigation, perjury, that they have no initiatives, no programs, for example, that run afoul of this DCL directive, right? The problem there is that institutions have always had to submit certification requirements, always, right? And as a matter of fact, just less than a year before this February 14th letter, the institutions had done that, right? So why, a year later, are you now requiring them to do it again? Right? That's why this looks like a legal rule or a legislative rule and a final rule, because they are, once again, tethering enforcement and punitive consequences to completing that certification requirement that is now a part of the DCL. So that just sets the stage, right? So you have to, as an initial matter, a court can examine legal rules, final rules, right? Legislative rules that have the air or in operation are in fact behaving like final rules. Then you get to these requirements of what are you supposed to do? What is an agency supposed to do when it wants to implement a new rule? Right? What is it supposed to do? Well, first and foremost, they have to provide notice and comment, where they notify everybody in the world, we're about to revisit this rule, or we are thinking about implementing this new rule. Right? It goes into the congressional record, et cetera, et cetera, et cetera. Here, they put it in a footnote of the Dear Colleague letter. If you got any complaints, you got any issues, here's the email you can write your complaints to. Right? That's not the way you do it, right? That's not the way you give notice and offer or invite comment, right? There's also concern about their approach violating the Paperwork Reduction Act, right? By just what I was just referring to, by requiring, for example, these institutions such as ours to issue another certification again that we are in compliance with whatever the DCL says we need to comply with, right? The Paperwork Reduction Act is something that is administered or managed by the Office of Personnel Management, more specifically, the Office of Management and Budget. And it was passed in 1980 as a way of agencies to perform information gathering and data collection in a way that was more effective and efficient. And as the title said, to reduce paperwork and burdens that come along with having to provide documentation or information time and time again, right? And the PRA requires agencies seeking to collect information from regulated entities to conduct a formal, quote, an evaluation of the need for the collection of information, end quote, and consider the burdens of collecting that information. And that evaluation usually requires notice and comment, right? Then you get into what is often the meat of the concerns and considerations about a new agency rule. Whether or not that agency rule is arbitrary or capricious, right? And the standard being an agency's decision, in this case, the decision to construct and articulate and threaten and in fact enforce the operative terms and language of the Dear Colleague letter, that decision is arbitrary and capricious if, quote, the agency has relied on factors which Congress has not intended it to consider, entirely failed to consider an important aspect of the problem, offered an explanation for its decision that runs counter to the evidence before the agency, or is so implausible that it could not be ascribed to a different view or a product of agency expertise. And that's West Virginia versus Thompson. The government's failure to recognize that that it went beyond merely restating settled principles of Title VI and other civil rights laws, right, is enough. But they did other acts. They insisted that the letter and certification don't require any type of particular process, no notice and comment process. But they have no administrative record of investigation with regards to this Dear Letter Colleague. It's failed to consider any countervailing factors as to whether or not what they're saying in this Dear Colleague letter is appropriate, makes sense, is good or not, right? Change of position is another concept or principle, rather, that a court will explore, examine as to an agency action. FCC versus Fox Television. This is one of my favorite cases out of mass media, and it has to do with the indecency and obscenity doctrine on broadcast television. And it says that an agency is required to, quote, display awareness that it is changing position, end quote, and, quote, show that there are good reasons, end quote, for its new policy. Now, failing to acknowledge or explain a change is evidence, it said, that the agency, or say the government rather, has entirely failed to consider an important aspect of the problem, end quote, right? Here, the government changed its position, as I said before, one way of looking at it, or said one way rather, by asserting that certain discussions of race constitute discriminatory practices and violate Title VI and the SFFA. Now, prior guidance didn't mention any of that, right? The prior guidance that the OCR had given mentioned none of that, right? And the government has attempted to sort of explain away that lack of consideration about their changed position by saying that, insisting that anti-discrimination laws protect majority groups as well. Well, yes, of course they do, right? But nobody disagrees with that, right? What's new here is the requirements, the rereading and reconstruction and reinterpretation of Title VI and SFFA, right? So they could have, for example, just simply said, yeah, we want to focus on reverse discrimination, but they went farther than that, right? Letter and certification also represent a significant change in position because a prior guidance was removed back in January or February 2025 that interpreted the SFFA, providing that, quote, nothing in the SFFA decision prohibits institutions from continuing to seek the admissions and graduation of diverse student bodies, including along those lines of race and ethnicity, through means that do not afford individual applicants a preference on the basis of race and admissions, end quote. That's what the SFFA decision said, and that is what they had, the DOE at that time had interpreted it to say, or say that was their interpretation. Well, that was removed, that prior guidance was removed without explanation, and then said that prior guidance, that would be ignored. All right. So that's another example of the lack of thought that went into this new or changed position. With regards to prior factual findings and evidence, the agencies are bound to analyze relevant data and articulate satisfactory explanations for its actions, as well as rationally connecting it to the facts found and the choices made. That is, say, basing their new policy on evidence and on research. For example, in this case, by marshaling evidence, putting it into the record that there's been discrimination, systematic discrimination against white and Asian students, or that universities had embraced pervasive race-based preferences. It did none of that, right? With regards to existing state and federal standards, the Office of Civil Rights and Department of Justice seems to have sort of misinterpreted or misunderstood some of the baseline understandings of what they could do and could not do under Title VI and the SFFA. Right? The court or a court, in looking at agency actions or changes, can also look at reliance issues and reliance interests. That is to say that to the extent that organizations and entities such as schools relied on former interpretation and directives, but now have to change those, that those changes and the weight, the cost, the consequences of those changes should be and can be taken into account. Shuttering buildings, laying off workers wholesale who maybe did DE&I work or counseling or cultural competence training, right? Extinguishing programs. Those are all sort of factors or examples of ways in which institutions may have relied upon the former interpretation. How much? 2 minutes? Former interpretations to their detriment. And so that's another concern and consideration. Right? Constitutionality. right? We can make quick work of this.
We can go till quarter after. Like the schedule says quarter after.
Oh, okay, all right. Thank you. All right, cool. Thank you. All right. I don't want to be screedy. But yes, we can still make quick work of this. I get it. Here are just some examples of language in the Dear Colleague letter that I recommend to you, and that I suggest that those are just examples of ways in which we can look at this Dear Colleague letter and its constitutionality from the perspective of the First Amendment and the Fifth Amendment particularly. So we have sort of three threads with regards to the First Amendment, with regards to content-based discrimination, viewpoint-based discrimination, and compelled speech. Just to remind you, and once again, this is sort of underscores something that Professor Rosenblatt just had reminded us, is that we're talking about government action. We're talking about the federal government and what it can and cannot do with regards to First Amendment. This is not concern private actors and what they do or don't do with regards to First Amendment rights and abridging them, for example. And we know that any of these types of discrimination based under the First Amendment will be reviewed for strict scrutiny, right? Fatal in fact, as some of us are fond of saying or reminded of, right? So, First Amendment right prevents the government from prescribing speech, right? Even when expressive conduct because of disapproval of the ideas. You can't do that just because you don't like what someone is saying. Because the government has no power to restrict expression because of the views of its message or the subject matter of its content. That was held most pointedly in Texas versus Johnson, the famous or infamous flag burning case of 1989, right? Reed versus Town of Gilbert, Arizona, billboards and zoning laws, rather. Such laws are presumptively unconstitutional and look into an inquiry as to whether or not determining the content neutrality is whether the government is adopting a regulation of speech because it's agreement or disagreement with the message it contains, right? First Amendment doesn't countenance content-based regulations, not only content-based regulations, but also viewpoints, right? In terms, especially of matters of public interest, political issues, for example. Legislation or executive actions regulating speech, depending on the identity of the speaker, are also subject to strict scrutiny because you are seen as a way or method to control the content. Let me just go back to this briefly, I think. So we see here, for example, in the second bullet point, proponents of these discriminatory practices have attempted to further justify them, ... right? That's what they say in their colleague letter. That is an example of a viewpoint-based discrimination, where they are targeting those who convey a particular message. What this says is that someone who pronounces anti-DEI or espouses anti-DEI sentiments or expressions of behavior, perfectly fine. What you do is legal. We're not going to touch you, right? But if you are a proponent, we're coming after you, and this letter gives us the authority to do that. That's what's problematic with that constitutionally. Right? Flag, holding your hand over your heart when you and standing when you salute the flag. The West Virginia versus Barnett case, right, is the seminal case in terms of compelled speech. You cannot be made to stand up and put your hand over your heart and recite the Pledge of Allegiance, for example, right? That is conceding that's compelled speech more recently, 303 Creative versus Atlantis, and I think there's some rightful arguments about whether or not that the narrowness of that particular decision or not. Professor Hill may know something about this. I'm sure she does know a lot about this. But that said, right, unconstitutional conditions, right? The government may not deny benefit to a person on the basis that it infringes upon his constitutionally protected freedom of speech. Now, one of the things that I've seen in reading some of the cases, I've seen that argument sustained lesser degree than the others, right? The idea that the government is using, leveraging grant money by saying you got to do this over here, right? We're going to take away your grant money here if you don't do this, right? And so the question becomes whether or not that is an unconstitutional condition. There are so many contours to that concept and principle that we can debate whether or not it belongs in here as an argument. Then you get into this fundamental issues and notions of vagueness, and I'm closing now. The idea of the Fifth Amendment due process clause abhors vague rules and actions and conduct. The fundamental notion underlying the due process clause is that people of ordinary intelligence should know when they're violating a rule or a law. And if that rule or law is so vague as to not give someone notice as to when they are stepping into it or onto it, then that is constitutionally problematic, right? And so you have here the various phrases and terms that are used in the Dear Colleague letter that just have no meaning, aren't defined, have no tether to them, and historically have never been a part of evaluating whether or not discriminatory actions have happened. Stigmatization. DE&I, what is DE&I, right? The letter doesn't define it, right? What is equity, right? Host of things that make this Dear Colleague letter vague, right? Unconstitutionally vague. And the risk is that you leave it to the decision makers, the government, to decide, okay, you're wrong. They're going to require you to take an act and then say you're wrong or you're right, right? And so that is what the Constitution abhors, right? There's also this, I'll call it offensive because it is, undercurrent that courses through this Dear Colleague letter, as well as what we've heard in public conversations over the last year, 2 years, about DEI hires, about, well, I don't want to fly a plane if a black person is the pilot. I don't want to be in that plane, right? This whole notion that somehow just because somebody is of a particular identity, that brings tragedy and danger. Right? And that the fact that this Dear Colleague letter says that explicitly is the other consideration that gives us pause. So in closing, I had recommended some ways in which universities and institutions can sort of fight back or push back on this Dear Colleague letter, as well as the new initiatives and this new regime that this government has implemented. And so I won't go through all of those. What I do want to say, though, is what we've seen on college campus. It's not just college campus. It's not just public or private. It's this erasure of identity notions, an idea that these places still can be welcoming to people of various and all identities. And under this, and the sacrifice of this new approach. And what I think that has done is left those who are of those identities or who are allies of them feeling outside and looking, literally looking for places and peoples and programs that will make them feel a part of things. I think that universities and institutions, and we'll probably hear about this afternoon, for example, that can tether a new mission that doesn't dissolve or dilute their commitments to diversity, equity, inclusion, and belonging. They can do that by tethering their work and their to their mission statements, to other things that they do, even if they can't call it diversity, right? That there are other things that they can do and that they should do and that they should signal that they are doing for those institutions. Because, right, anti-discrimination still applies to us, right? It still applies. It's still illegal to discriminate against women, against black folk, right? Against LGBTQ. It's still illegal, right? And that's what they need to be reminded of. We also need to be reminded of the value of diversity, equity, inclusion, and belonging. That it still holds value, despite what they might think, right? So that's my spiel. That's my thought and on this. I thank you again, and happy to have a conversation afterwards. All right. Bye-bye.
Thank you so much, Professor Addison. We are going to adjourn now to the room across the way to have lunch, and I invite you, as we do that, to sit at tables with people you don't know that well, and discuss the issues we've talked about today, and particularly discuss what the role of government is in all of this, and whether the things that are happening now are different just in the way they feel or in more objective ways from things that have happened in the past. So let's adjourn, have some lunch, and have some roundtable discussions. We will be back here at, what does the agenda say? 1:30? 1:15. We'll be back here in 55 minutes at 1:15. See you then.
Don't you want to keep them here?
You're open.
See, yesterday I had up there.
I didn't even talk to you off the top.
You have your freedom of speech.
But your friend, it was like, please.
Oh, yes. Me too.
It was, you were gonna. So I was sitting
Really good. Participating and then like.
All right, let's get started with the afternoon session. I'm Dan Jaffe, and I'm a professor here at Case Law School, where I teach both legal skills and education law. And our topic for the afternoon is Curriculum Under Command, Federal Authority and the First Amendment in Higher Education. So it's my privilege to introduce our four panelists today. And bear with me, I will say they're four distinguished panelists because they all have very impressive resumes. So, and they each asked me to embellish on their resume as well. So bear with me for a moment. I'll introduce them all, and then they can come up in turn. Our first panelist is Robert Shibley, and he will talk about higher education's political reckoning and how colleges enabled Washington's power grab. He is special counsel for campus advocacy at the Foundation for Individual Rights and Expression, also known as FIRE. He has more than 2 decades of experience in FIRE's efforts to defend liberty at America's colleges and universities. He was the organization's executive director from 2015 to 2022. He spent some time in private practice as well, where he represented students and faculty in private litigation, tenure and disciplinary matters. At FIRE, Shibley led the organization's expansion beyond campus and its development of litigation and legislative advocacy, including efforts related to the 2020 Title IX regulations. He conceived of and helped launch FIRE's Stand Up for Speech litigation program, which ultimately achieved 13 victories against campus speech codes in 15 federal cases. He is also the author of Twisting Title IX, and his commentary has appeared in the Wall Street Journal, USA Today, the Washington Post, Time, and other outlets. He has also commented on NPR, CNN, Fox News, and other national media, and one of 2 on our panel, 2-time graduates of Duke University. Our second panelist is our own Atiba Ellis, and he will talk about the efforts of the federal government to transform educational policy, that they represent a thinly coded censorship of critical race theory as an academic literature and as a proxy for attacking race-conscious discourse within higher education generally. Professor Ellis is the Laura B. Chisholm Distinguished Research Scholar and Associate Dean for Enrichment and Engagement, in addition to being a professor at Case Western Law School. A nationally noted voting rights scholar, his primary research focuses on how racial and class-based oppression interact and continue to abridge and deny the right to vote to communities on the margins of American democracy. His work has analyzed voter identification laws for their socioeconomic effects, situated felon disenfranchisement laws as enforcing a political underclass, and has analyzed the scope of the Citizen United decision as well. Another 2-time graduate of Duke University. Our third panelist, Samuel Bagenstos, am I saying it right? Bagenstos. Samuel Bagenstos. He will talk about funding termination as a sanction for Title VI enforcement. He's the Frank Millard Professor of Law at the University of Michigan Law School and the Arlene Susan Cohn Professor of Social Policy at the University of Michigan Gerald Ford School of Public Policy. He recently returned to Michigan after a 4-year leave serving in the federal government, where he was special counsel to the Department of Health and Human Services. He also has also served as general counsel to the Office of Management and Budget. Additionally, he has been an appointee at the U.S. Department of Justice, where he served as Principal Deputy Assistant Attorney General for Civil Rights, the #2 official in the Civil Rights Division. He has published articles in journals such as the Yale Law Journal, Stanford Law Review, Columbia Law Review, California Law Review, Virginia Law Review, the Cornell Law Review, and the Georgetown Law Journal, and many others. 2 books on law, one called Contradictions of the Disability Rights Movement, and another Disability Rights Law Cases and Materials, and has written articles for non-academic audiences as well. He has argued in front of the Supreme Court 4 times, and additionally argued multiple times in the Michigan Supreme Court and federal courts of appeals. And our 4th speaker tonight is Dr. Christopher Thomas. He will speak on A Tale of 2 Emails, looking at institutional decision-making in the current political environment. He's an associate professor of educational leadership and policy at the University of Florida College of Education and an affiliate faculty member with the University of Florida Levin College of Law. He has a PhD in educational studies, specializing in educational policy, and a JD from the Ohio State University. In his prior iteration, he worked for the law firm of Frost Brown Todd LLP, where, like yours truly, he represented school boards. Let's see, judicial extern for Chief Judge Guy Cole, the U.S. Court of Appeals for the 6th Circuit. His research focuses on the intersection of education law, policy, and practice, with special attention to issues of democratic governance and participation. He also podcasts. Like I said, a very distinguished panel. Without further ado, let's start with Robert Chibb.
It's the right arrow.
All right, cool, thank you. Well, thank you for having me, and thank you, Law Review and Maggie and everybody for arranging this. It's the title of my slideshow is probably going to be more exciting than the content of the slideshow. Partly because I have been rewriting it a little bit as we went through this morning, and I don't want to belabor things too long, but what I basically have is an outline of the things that have gone on, and you're going to hear a lot more about, the details of how those have gone on. But I'm going to provide sort of a basic outline of a bunch of the things that have happened. Frankly, so many things have happened, I probably will miss some, but then one thing I do want to talk about in a little more depth is the what FIRE has come to call the cumulative theory of Title VI harassment, that has been going around through now 2 administrations. So, okay, so federal pressure on colleges post-October 7th. That's Columbia there, and basically this came, in my opinion anyway, in sort of 3 overlapping and sort of indistinct, but nevertheless, distinguishable ways. The first one being the Inquisition phase, and the symbol of that is the congressional hearings, particularly the one from December 2023, having to do with protests and anti-Semitism on college campuses where they had Ivy League presidents there. The second one, regulation, and this is where I'm going to spend sort of the meat of my time talking about what's going on with Title VI, which is the older and sort of original progenitor to Title IX, which is what what Fire and I particularly have spent a lot of time in the past decades dealing with, and then inundation, because I wanted to end in shun for the 3rd time. I felt like that would be good, and that's as good a description as any of all of the things that have been happening since probably around March of this year under the Trump 47 administration. Okay, so let's remember what happened in the Inquisition wave. October 7th, 2023 were the attacks on Israel, and Israel, I went back and looked at, by about a week later, they were striking Gaza in pretty, in a pretty big fashion. So by the 16th, we were already seeing pro-Palestinian protests hit a lot of the major universities, and the ones that really stuck out the whole time, the one that stuck out the most was Columbia University. I think part of that is because of the nature of Columbia as a place that is congenial to protest sort of traditionally, or maybe if not congenial to protest, at least one where it's a tradition to do that. But I don't think we should overlook also that it happens to be in Manhattan, and you can easily get there if you want to cover it for the news. But Harvard and Penn also had big protests, but so did places like UNC and Indiana University. I don't know what it was like here at Case, but I can tell you that Indiana was kind of an interesting one, and I won't get too far into this, but Indiana is actually so Fire, for those of you who don't know, defends free speech. We were founded to defend free speech on college and university campuses back in 1999, but in 2022 or 3, we expanded our mission to start defending speech off campus as well. But we still do all of our campus work, and one of the things that we are known for is these campus free speech rankings. And one of the schools that tanked the most this year was the University of Indiana, or Indiana University, and we think the reason for that is, we do the polls and we poll statistically significant numbers of students each place, but a lot of them commented on this because we have an open response place, and one of them is Indiana hired snipers to oversee some of the protests. They actually had snipers on the roof of a couple of buildings, and believe it or not, that does make an impression when people are standing up there with a rifle over you, which we said was ridiculous at the time, and I think Indiana University's general counsel is no longer our friend, I think is probably safe to say. They're not really our BFFs anymore. So a lot of things, it was very intense, and you all probably remember that, but it's easy to lose sight of how intense it was at the time. By December 5th, the House Committee on the Education and the Workforce had assembled this now sort of famous or infamous anti-Semitism hearing with the presidents of Harvard, the University of Pennsylvania, and MIT. And you probably more or less remember how this went. So that was, December 5th. By December 11th, the president of Penn had resigned. These hearings did not go well. And by January 2nd, sort of after pressure from the hearing, but also allegations about plagiarism, Harvard's president, Claudine Gay, had also resigned, and she became the Harvard president with the shortest tenure in history. Now, what went so wrong at these hearings? There's a lot of different ways you can look at this, but one of the ones I want to look at quickly is that the questioning itself, if you go back and read it, you can see a level of sort of skepticism and hostility from the congressional representatives that you don't usually see when dealing, or you hadn't previously seen when dealing with Ivy League presidents. Representative Wilson asked President Gay, I want to know what is the percentage of conservative professors at Harvard? Ms. Gay said, I do not have that statistic. We do not collect that data. Harvard itself doesn't, but the Harvard Crimson actually does that every year. In 22, they went through and they looked at the professors and they found 37% said they were very liberal, 45% liberal, 16% moderate, 1.5% conservative, and 0 very conservative. And I don't mean 0%, I mean literally 0 people, right? And so just to give a comparison of how that compares to the same year overall average citizens of the United States, 37% of Americans said they were moderate, 36% conservative, 25% liberal, 9% very conservative, and 7% very liberal. So as that kind of knowledge has become more and more, it's filtered through, we've started to see politicians be more and more skeptical about claims that universities are making meaningful efforts in terms of having intellectual diversity. Let's see. Representative Grothman went after President Gay at Harvard, also having to do with the students' voting record. Again, obviously far to the left, etc. And also, most famously, Representative Stefanik went on kind of a tear about what Harvard would allow to be said on its campus, and President Gay was saying, well, we value everything, we tolerate all kinds of expression. What did she say? We embrace a commitment to free expression, but as I was sharing with folks at dinner last night, we had just a couple of years before had a fight with Harvard at Fire over their demand to a student to take down a flag that they were hanging, they had hanging in their dorm room that was Nicki Minaj in a bikini saluting in front of the American flag. And you wouldn't believe the level of resistance Harvard put up against us about having this flag up. So again, the reason I bring this up is not to to some extent to pick at Harvard because I enjoy doing that, but also because I think it's summed up well. I talked to during this whole mess. I talked to a journalist who said he was interviewing on different things, and one of the things he asked, who are the constituencies, there, and he said one of a top Democratic senator had said that Hamas has a bigger constituency in this country than Colombia does right now, and that kind of sums up what it was looking like from the political perspective. So that was the Inquisition. Okay, regulation. So in November 2023, OCR, which is the Department of Education's Office for Civil Rights, started launching these Title VI anti-Semitism and Islamophobia investigations. They launched originally with Columbia, Cornell, Wellesley, Cooper Union, Penn, and Lafayette College, which is in Pennsylvania. And by March of 2024, this had risen to at least 46. And we started to see the results of those in June of 2024. So this is, the waning days of the Biden administration. So what we learned from that was this. So the definition of hostile environment, discriminatory harassment in the educational context, so far as it can be determined, comes from a case called Davis versus Monroe County Board of Education from 1999. It's a Supreme Court case. It was written, it's a 5-4 case written by O'Connor and joined by the court's 4 liberals. And they repeat this standard 3 times. They say hostile environment is, and I paraphrase it here a little bit, but you can look it up. I encourage you to take a look. Hostile environment has to be targeted against somebody. It has to be discriminatory, so it can't just be based on hostile environment. To be discriminatory harassment actually has to be discriminatory. It can't just be hostile because they don't like you personally. It has to be so severe, pervasive, and objectively offensive that it effectively prevents the victim from getting their education. Now, what we saw in June of 2024 was this in the Title. So that was a Title IX case, right? In the Title VI context, which is a parallel statute. Title VI, like I said, is sort of it's the statute from which Title IX was derived, and the courts have been explicit that you can apply the principles from one to the other when it makes sense to do so. They said that for Title VI, which does since about 2004, which all parties sort of have agreed to decide that it covers anti-Semitism and Islamophobia along with race, color, and national origin, which is what is actually written in the text of the law. OCR, they said that what Lafayette and other colleges had failed to do was assess whether the incidents individually or cumulatively created a hostile environment for students, faculty, or staff. Now, this is where it gets kind of in the weeds, so I'm going to give you sort of an example, and this is what happened with Lafayette that really triggered a lot of concern at FIRE, and I think should concern people here because of the way it impinges on protected speech. So here's one of the examples that OCR gave. And they said this is at Lafayette College, at an October 25th, 2023 rally, a pro-Palestinian student held up a poster saying, "From the river to the sea," okay? And you all are probably familiar, it's a very controversial statement. People have, different opinions on what it means, but here's what happened. So students immediately went to Lafayette's president to complain about it. The college chaplain, who is kind of amusingly also the head of the bias response team, the director of educational equity, and also the Title IX coordinator, called the student who held up the poster, told him that the phrase was hurtful and could be viewed as anti-Semitic. Then Lafayette's president emailed the campus community about the poster. The campus group that organized the protest said that we stand against and detest hate speech and they're against anti-Semitism. Then the chaplain met with the poster holding student again. The student agreed, told the chaplain, "I will not hold that poster in future protests." And so you would think, all right, mission accomplished. We've gone through this, everybody's reacted, if anything, maybe a little heavy-handedly for somebody holding up a sign. Unfortunately, OCR said that wasn't enough. They said that what Lafayette and what Michigan and what all of the sort of following colleges were expected to do was every single time there was an allegation of something that could contribute to a hostile environment, the colleges were now required to evaluate whether or not that had created a hostile environment sort of unmoored from necessarily being aimed at a specific person or group of people. And this is why that's important, because what it does is it means that you can have a free-floating hostile environment where instead of the hostile environment, which traditionally has been, is this student, like in Davis, it was a student named LaShonda Davis who was being exposed to some really pretty foul behavior for a fifth grader, frankly, and it created a hostile environment for her personally. The question OCR was trying to evaluate was, is this a hostile environment for Jewish students or Islamic students more generally? So you could even come late to the hostile environment. In other words, the environment could span the summer, we learned from it. So you could have, if you were a freshman who was coming in the fall, the hostile environment could partially be caused by things that happened in the spring before you got there. It also meant that if you were a freshman holding up your sign in the fall, you could be contributing to a hostile environment that was started by the people who left before the summer was over. And so we have this key to sort of regulating generally sort of like the vibes of a particular campus and giving OCR the power to regulate that in a way that it suggests that the only way to deal with it is to actually clamp down on protected speech, and that sort of comes out of the illustrations that OCR gave in so many of those. So that was a big concern. I think sort of the highlight of what I wanted to point out from the Title VI jurisprudence, and happy to answer questions on that later. Then finally, and I'm sure we're going to be hearing a ton more on this. Oh yeah, sorry. Forgot I made a fancy one. Okay, I usually don't do that. Oh yeah, they always love to have a Trump tweet there. So March 2025, you started to get Trump's multi-pronged attack on all things college, and even though most of the things that the Biden Department of Education did, Trump purposely did the opposite and vice versa. The cumulative theory of harassment was not one of those. Even though they're no longer using quite the same terminology, the effect has been the same. This is one of those areas where there's been some bipartisan agreement, which personally I could do without in this particular case. Obviously, we had the research funding cuts and freezes that I know we're going to hear more about. We've already heard a bunch about. Threats to accreditation. This kind of went under the radar, but they actually made a pretty good run at Columbia University's accreditation. The Department of Education informed the Middle States Commission on Higher Education that Columbia was in violation of Title VI, and Middle States put Columbia on warning status. They made it clear that they had not been de-accredited, but they were in fact, going to go forward with an investigation. Which, I mean, that'd be a pretty big deal if you de-accredit Columbia University. Of course, the deportation of pro-Hamas foreign students, and I put that in quotes not because I'm judging, but because that was, the idea is these people must be pro-Hamas. That included Rumea Ozturk, whose big offense was co-signing onto an op-ed in the Tufts Daily that wasn't even all that, hostile to anybody, and then freezing the student visas and suspending the participation. At one point, they actually revoked Harvard's ability to have all foreign students. That lasted a day until a judge shot it down, and that's still being litigated. But at one point, 1,800 individual students at about 260 schools across the country had been informed they had lost their student visas or they'd been terminated. Now, on April 25th, those were all restored, but again, you can see the kind of interorum effect that has. If you think that you step out of line, you might lose your student visa. How anxious are you going to be to speak out on college campuses? And one thing that I think is worth mentioning is how anxious, if you're an American student, as most people here are, obviously, how anxious would you be to hold an event where you might be exposing your roommate or your friend or whoever who's from Canada or Britain or Saudi Arabia or China, wherever it might be, to being deported if you basically say, go team to what it is you're saying. So if you're saying, I think the Israelis have gone too far in Gaza, and they say, yeah, I agree, they can be deported, are you going to say that? And I think there hasn't been enough consideration of whether or not of the effects of that. So anyway, I will move on. Thank you, and happy to take questions after.
Well, good afternoon. Get comfortable. But unlike my property students who are probably thinking right now, oh boy, Ellis is settling in, I will start a timer so I make sure I try to stay close to my 20 minutes. So it's a pleasure to be here today, and I want to thank the Law Journal and in inviting me. And in case it wasn't mentioned this morning, I am admittedly a last-minute addition to the panel because our prior panelist had a medical issue that prevented him from being here. And so in some ways, I realize that I am a little bit of a odd duck here. And in some ways, though, I think I am a bridge between this session and the morning session and Professor Adamson's keynote, in as much as I want to tell an account that is rooted in concerns around what the work that universities do by thinking specifically about critical race theory as a literature within law schools and how that has been transformed into a piece of the sort of anti-DEI conversations that we saw this morning via Professor Adamson's keynote about the federal executive orders that sort of bring us into, the topic of this panel around higher education and curriculum, and in essence, bringing the claim forward that CRT through these methods is directly under attack, specifically as a piece of the curriculum of law schools and its sort of related study of history and culture and society through a validly race-conscious lens, which, by the way, is not CRT. And so to make that distinction very clear, which is part of what I will do in my time, but that this is, as Professor Adamson suggested, a content-based restriction, right? This is a direct attack on a direct piece of a curriculum, and places like Case Western Reserve University and the law schools that are represented here today all teach in some way, shape, or form, or not, but it's their choice to do so or not, and it is the choice of the scholars to produce knowledge of that sort or not. But to have the federal government impliedly dictate knowledge that is forbidden versus knowledge that is accepted, and to announce quite loudly, as happened in the Dear Colleague letter of February 14th, that certain knowledge is specifically disfavored, raises deep concerns about both the state of universities, the state of higher education, and as you heard from the introduction, my day job as a scholar is a scholar of the law of democracy from a critical theory lens. It raises concerns about democracy and ultimately makes us have to wonder whether these claims about being a democracy with its essential ingredient of free discourse, right? The First Amendment is the First Amendment that was ratified, not the First Amendment that was proposed, but it was the First Amendment that was ratified, and is important because freedom of thought is the thing that enables us the freedom to vote and to assess how our representatives represent us. Now, one quick qualification that I want to make clearly, because I also now sit on the administrative floor rather than the faculty floor, my comments do not speak for Case Western Reserve University, the School of Law, or the Office of Enrichment and Engagement. And in fact, saying that leads me to a particular first thought, right? I can have two hats. I can play multiple roles. And part of the challenge of education put broadly is to create minds that are able to hold different thoughts at the same time and then being able to pick and choose what thoughts are necessary and proper for our own lives that we get to choose to live in the ways that we wish to live. And if that is the case, then, if that is in a sense the heart of freedom, then to impliedly or even directly suggest that certain forms of knowledge are, quote, divisive, discriminatory, stereotyping, stigmatizing, on the basis of mere assertion, rather than inquiry into the kind of knowledge and the articulation of specific facts in particular circumstances, which we heard my colleague just talk about. We want to know exactly what happened and why. But to just simply assert certain ideologies are disfavored by this government seems to cut against what the government claims we ought to be out to do. So a few thoughts. One, as you can tell from the tenor of my, commentary here, I believe that this is ultimately an ideological project, right? As we heard in the morning panel, that describing things as a racial project is an important act of naming, and that we can then critically examine how that naming, and it can be racial, it can be subordinationist in the sense of one's abilities or the type of content, but also the kind of power that the state wishes to assert, right? So maybe this is an identity project, a racial project specifically, and even a project in terms of defining state power. And it's seen through that lens, the concern about deciding what thoughts are appropriate and what thoughts aren't appropriate signals, at least for me, a disturbing trend, right? That we might be seeing a governance that is at least implying, without wishing to look like that it's implying, that the disturbing nature of sanctioned thought and privileged people who get a heightened status in society as opposed to others is actually beneficial to a certain conception of the state. And that this should be accepted by silencing those who would say that what I just named is what's happening, and that it ought to be known as a divisive act through the act of calling the thing that is a critic of the state divisive. Or in other words, by accusing critical race theory and race-conscious thinking and over-expanding Supreme Court precedent and arguably exceeding the scope of executive power, there is a political movement that wishes to assert power by blaming the powerless for attempting to overtake American values. And by doing so, redefining American values, an inherently contested space, if there was ever one, as something that benefits a certain group, indeed may benefit a certain kind of majority, but then masks what Lonnie Guinier called the tyranny of the majority that is imposing these thought restrictions. So I want to move through this to make a couple of observations. One, I want to talk about what critical race theory is and is not. Two, I want to talk about an important theoretical intervention briefly in terms of colorblindness and post-racial theory, which sort of undergirds both what we do here in law schools, but at the same time gives us an insight as to the intellectual grounding of some of this controversy that I want to lead to. And through that lens, I want to briefly do a reprise of what we heard during the keynote in terms of the executive orders, but reading them as coded censorship of critical race theory. And then I'll end with a few thoughts on the consequences of this. So what is critical race theory? Briefly, and I want to work through that phrase backwards. So when we think theory in an academic sense, because as I said, we're talking about academic literature here, right? A theory is a system of ideas intended to explain something, especially a system based on general principles independent of the thing to be explained, right? A theory takes an observational perspective and runs through assumptions about the thing it's observing. So critical race theory, well, if we talk about race, I think most people in society would agree that race is a social construct based on the idea that humans can be identified and categorized into groups based on physical characteristics such as skin color, eye shape, etc. Most of us agree that this is an idea, even though we realize that the rhetoric of race being real, salient, important, and deserving of social hierarchy is an idea held by others, right? And in that sense, there is discriminatory race projects out there. The idea feeds this, despite the fact that we can say to ourselves it has no basis in biological fact, but we can perceive as an ideological project that there are groups that ought to have power and ought not to have power. And I think a democracy, however, can't exist when we accept that premise, because then it becomes something else, right? If there is a favored group and a disfavored group because of race, it becomes something else. The tension between the salience of that idea and how it exists and moves through the world and what effects that it has can be thought of as racism. And in a way, we're using racism as a lens to understand power dynamics and competition, right? The belief creates prejudice, and the effects of that prejudice can be overt or covert, but have consequences. And understanding the nature of those consequences is the critical part, right? The analysis that seeks to confront those ideological, social, historical consequences and what they mean and how they have impacts, especially when it is hidden and coded. That is what the critical race theory school of research is out to illustrate. In the words of Richard Delgado and Gene Stefanik, right? The critical race movement is a collection of activists and scholars engaged in studying and transforming the relationship among race, racism, and power. So, if we read through that lens, then the movements that we have been talking about today and the exercise of executive power that has been the focus of our study then becomes trying to understand how power is excising certain forms of thought to serve its own purposes. So to explore that, let's take into account one of many things that I could point out in this theory, but I only have 8 minutes left. So I would pick on one sort of concept near and dear to the heart of how the law thinks about racism, which is colorblindness, right? The notion that we should and ought to live in a society where the law treats everyone equal, right? We pick this up from John Marshall Harlan's dissent in Plessy. Our Constitution is colorblind and ought to know no discrimination, and everyone should be treated as such. Now, whenever I get to talk about Justice Harlan and our Constitution is colorblind, I feel the need to read the entire paragraph where that sentence is drawn from. So let me just read. The paragraph starts, "The white race deems itself to be the dominant race in this country, and so it is in prestige and achievement and education and wealth and in power. So I doubt not that it will continue to be for all time if it remains true to its great heritage and holds fast to the principles of constitutional liberty. But in the view of the Constitution, in the eyes of the law, there is in this country no superior dominant ruling class of citizens. There is no caste here. Our Constitution is colorblind and neither knows nor tolerates classes among its citizens. In respect of civil rights, all citizens are equal before the law. In one paragraph, we see both our Constitution is colorblind, all citizens are equal before the law, and the white supremacist racial project. So if anything else, stop and think to yourself, well, wait, these two different ideas exist in the same place. And notice we have spent over a century, and this ideology has motivated conservatives, liberals, and everyone in between, but we have picked and chosen what it ought to mean. Its latest iteration, I have argued in research, drawing on Professor Sumi Cho's work, is post-racialism, right? That racism is over. Hey, we elected Obama. Hey, we have moved on to something new and different, and therefore we need not talk about it anymore. And talking about a race actually becomes damaging and dangerous and stigmatizing and divisive, right? And mind you, the thrust of my remarks, which I will get to us in a second, is to speak specifically to the moment of this administration and what its Dear Colleague letter means in regards to that. But actually, let me start by focusing on the so-called left, right? The left embraces post-racialism in the form of, well, we have overcome. We can move on to talking about other things because we have the Civil Rights Act, the Voting Rights Act, we have Title VI, we have all of these things. And those things show that we are a formally equal society, and therefore we can have conversations about other stuff. But when I wrote this article before the Trump era, the right was sick and tired of being beaten up about being accused of being the racist. And it wanted the end to this debate and this discussion. And so we have this agreement about moving on. And yet we see the era of Trump. And as a law of politics scholar, I can't help but think about how the Trump presidential campaign started with what I have called in other work, racially coded messages, right? And I've written a whole essay about the racial coding in terms of the 2020 election, where illegal voters and bad election administration was directly targeted at cities that were of majority people of color. But then the Trump administration, and deeply criticizing, in basically every election, whether he won or he lost and then he won again, the sort of notions of voter fraud that I argue are racially coded, even in elections that he's won. But Trump too comes in. And of course we get the Dear Colleague letter. But that also has to be read in the context of the executive orders that targeted the alleged teaching of CRT in K-12 education. But as I said earlier, simply teaching history is not critical race theory, because critical race theory does a specific job of criticizing structures and structural racism and not simply reporting the facts of things like slavery existed and Jim Crow existed, and that you need this basic knowledge to understand why equality is valuable today. But if we go straight to the Dear Colleague letter, it is a message written to universities to stop indoctrinating with divisive ideology and to stop specifically speaking in race-conscious terms, right? It, quote, says, a false premise that the United States is built upon systemic and structural racism, directly cutting at what CRT is about. It speaks in DEI, but that spills into intellectual traditions that would endorse DEI, right? And like I said, this language of discriminatory, stereotyping, and stigmatizing is the government in and of itself picking content to target. Now, this is despite its justification in SFFA versus Harvard College, which in and of itself has no textual justification for such an expansive interpretation. It only speaks to race-conscious tools used in the admissions process, and no more, and indeed creates carve-outs for military academies who are seen, and the court knew would be perceived as having a different kind of relationship with the public given the mission of the military. And there are other things that we could say about statute, and I refer you back to my colleagues' comments about the First and Fifth Amendment, except to say at the end of my time that this is ultimately, I would argue, trading on a myth that talking about the legacy and history of racism in a critical way, whether it's via professional critical race theorists or simply reciting the history in things like the 1619 Project, or the supposed threat that has been addressed on state and local levels in school districts of CRT, that trading on this is ultimately a project designed to create a diversity of thought that is not diverse. And it allows for a tyranny of the majority and accepted forms of thought that make those in power comfortable to be what ought to be the norm, and those who are not comfortable are disfavored. And so in this sort of amplified post-racialism that seeks to not only erase race, but to persecute those who might say those words, we have a danger. And I wrote a whole thing that I could go on in further detail about, but let me leave you with this thought that ultimately there is a problem of academic freedom in as much as this trades on the mismatch of intellectual diversity as measured by those who create knowledge with intellectual diversity as a form of diversity with which the majority is comfortable with. And the majority using its power to pursue its comfort does damage to the institutions that produce knowledge, innovation, and transformations that economically, politically, and socially, and I'll say this with all due irony, made America great. Thank you.
So I'm going to break the norm by standing for a few reasons. One, it's after lunch, and if I don't stand, I might keel over myself. I really appreciate the opportunity to talk here. I love this campus. It's so beautiful, and I've had many terrific experiences here. This has been a really generative symposium, and I really appreciate being on the panel with these folks and the folks who were here this morning. I will say, as a graduate of the University of North Carolina who teaches at the University of Michigan, the fact that you put me on a panel with two Duke graduates and an Ohio State graduate, but I guess it does suggest that the person who was here this morning who complained about a lack of diversity on the panels didn't entirely know what he was talking about. Maybe should have waited around. In any event, so our panel is about federal authority and the First Amendment in higher education, and I have a lot of things that I could say about the First Amendment in higher education. I'm going to talk about the federal authority side and maybe pick up a little bit on some of what Robert was talking about, drill down a little bit, because one of the most significant tools that this administration has used in its attack on knowledge-generating institutions, and in particular academic institutions, and I would argue not just their academic freedom, but their speech, has been the funding cutoff remedy under the civil rights laws, particularly Title VI of the Civil Rights Act of 1964 and Title IX of the Education Amendments of 1972. And what I want to say, as a person who grew up as a civil rights lawyer, started my career at the Civil Rights Division of DOJ, had the opportunity to return there as a political appointee under President Obama, is that the funding termination remedy we have seen is misguided and ought to be eliminated. And, I think I now hear many of my friends in the civil rights community saying, what the bleep are you doing, Bagenstas? So hear me out, because I think it actually makes sense. And sometimes I just provoke. That's not what I take this as. I really think all of those of us, and I spend a lot of my time working with folks in academic institutions and elsewhere who are fighting against these attacks on their academic freedom and these attacks on their ability to generate knowledge. All of us who are involved in those fights have an obligation to be thinking about what happens in the future and how we reform our institutions in the future, and this is a reform that I think is important. So let me just start with just orienting what I mean by the funding termination sanction. The major civil rights statutes that apply on campus take the form of federal funding conditions. Title VI of the Civil Rights Act of 64 is the model. The idea is if you are engaged in a program or activity that receives federal financial assistance, you agree that you're not going to discriminate on the basis of race, etc. And the idea behind that, there's a very often quoted line from Senator Hubert Humphrey, the principal supporter of the Civil Rights Act in the Senate, who said, look, simple justice requires that public funds to which all taxpayers of all races contribute not be spent in any fashion which encourages, entrenches, subsidizes, or results in racial discrimination. So the idea is, look, we're all paying for this, and so you can't be excluding people from the benefits of it. Simple justice. And so these laws, they apply only to programs or activities that receive federal financial assistance. Title VI was the original one. Title IX, which is sex discrimination educational programs, explicitly follows the same model. Section 504 of the Rehabilitation Act of 1973 prohibits disability discrimination, follows the same model. Section 1557 of the Affordable Care Act prohibits health care discrimination, similarly follows the same model. It applies to federal programs or activities with federal financial assistance. And the primary remedy set forth in these statutes, indeed the only explicit remedy set forth in these statutes, is termination of funding. And so Section 602 of the Civil Rights Act says compliance with any requirement adopted pursuant to this section may be affected, one, by the termination of a refusal to grant or continue assistance under a program or activity, or two, by any other means authorized by law. So the only explicit remedy is funding termination. It's very common to talk about the funding termination remedy as if it gives the federal government enormous power. And in particular, and I'm sure Robert, when he was criticizing Title IX as it was interpreted by the Obama administration, was saying this, because most of the critics of the Obama administration's Title IX interpretation, by the way, that wasn't my part of civil rights then. So, I've written about this and defended some of what the Obama administration did and criticized others of what the Obama administration did on this. But, the critics of the Obama administration's very significant moves under Title IX said, look, most institutions can't go without their federal funding. And so that means they are going to knuckle under even to overexpansive interpretations made by administrators of these federal funding connected statutes because they're afraid they'll lose the money. Yes, perhaps as a formal matter, they could go to court and challenge it, but they won't, because the risk that they lose their funds is so great, this sword of Damocles is so sharp and heavy over their heads that they're not going to challenge it. They're just going to knuckle under. And that was essentially the critique of various things that the Obama administration did under Title IX. Again, the critique took two forms. One was the Obama administration was overreading Title IX. I think an arguable point, but certainly a fair one. The other was that the Obama administration's actions were not just unlawful in the sense that they went beyond what Title IX required, but they were lawless because they were calculated to avoid judicial review by threatening such great sanctions. And I will say that second point is something I've also written a fair amount about, and I just have always said that doesn't make any sense, because at least until the last 8 months, the fund termination sanction has hardly been a powerful interim tool. In fact, it's barely been used at all. So the leading study of Title VI in 1995 wrote that the termination of federal funds is a most difficult and awkward sanction to invoke, and had been used at that point, 30 years ago, in no more than a handful of cases in the previous 2 decades. And this author said there is little prospect of seeing a substantially different record anytime soon. Well, that was true. We're 30 years later, so that's not soon as of 1995. But the crucial thing is it was only very briefly that the funding termination sanction was used at all, just for a couple of years during Lyndon Baines Johnson's administration, in the immediate aftermath of the adoption of Title VI, in school districts that more than a decade after Brown v. Board persistently refused to segregate. And even there, as I've written in earlier work, OCR very quickly reversed its funding terminations in nearly every case. And Title VI race discrimination represented the high point of the funding termination sanction under these statutes. So with only one very minor exception, the federal government has never cut off funds for a violation of Title IX. The federal government has never cut off funds for a violation of Section 504 of the Rehabilitation Act. And the federal government has never cut off funds for a violation of Section 1557, at least until Trump 47, the second Trump administration. There are a few reasons why, far from having significant bite, the fund termination sanction has barely been even a nibble. Number one is that Congress imposed a lot of very significant restrictions on the funding termination sanction. Some of these are procedural. So there has to be an express finding on the record after opportunity for hearing of a failure to comply with the statute. That's statutory language from Section 602 of Title VI that I was just reading. Also, and there's a lot of confusion about this point, the statute says that any funding termination cannot extend to the entire entity that has been found on the record after a hearing to violate Title VI or Title IX or 504. Instead, the funding termination shall be limited to the particular political entity or part thereof or other recipient as to whom such a finding has been made, and shall be limited in its effect to the particular program or part thereof in which such noncompliance has been so found. Now, a lot of people, in fact, a lot of people who should really know better, think that that provision was eliminated by the Civil Rights Restoration Act of 1987, which which defined program or activity to include all of the operations of an entity that receives federal financial assistance in any part of its operations. But that is not right. What the Civil Rights Restoration Act did is it extended institution-wide coverage, saying if you accept $1 of federal funds, your entire institution must not discriminate on the basis of race. But it continued to limit the funding termination remedy to the particular part of the program that was found to violate the statute. And it's not just that they left the language in the statute and they somehow forgot to take it out. In fact, if you read the legislative history, you can see that this was an intentional decision. Page 20 of the Senate report of the Civil Rights Restoration Act says the bill, quote, will leave in effect the enforcement structure common to each of these statutes. The section in each statute states that the termination of assistance shall be limited to the particular program or part thereof in which such non-compliance has been so found. The bill ... leaves intact the or part thereof pinpointing language. And the Senate report specifically endorsed what it called the seminal ruling, and I hate metaphorical language in that one in particular, the seminal ruling of the Fifth Circuit in a case called Taylor County, and it said, under the Taylor ruling, federal funds earmarked for a specific purpose would not be terminated unless discrimination was found in the use of those funds or the use of those funds was infected with discrimination elsewhere in the operation of the recipient. So you have to find a direct connection between discrimination that you found and the funds that you're taking away. What the Civil Rights Restoration Act said is the substantive obligations apply institution-wide, but an injunctive relief for violation of the statute could extend across the institution, but fund termination has to be limited to the particular part of the program where the violation was found. That, and I could, cite more about that, but when you read the paper, you'll see. But that also makes it very difficult to use funding termination as a sword of Damocles that's going to chop off the head of a violator. Also, the statute says that funding termination can't be taken until the department or agency concerned has given notice to the violator and given them an opportunity to comply and determine that compliance can't be secured by voluntary means. So there's an exhaustion requirement, and funding termination can't occur until 30 days after a report is filed with Congress, basically to give the members of Congress in the district where the funding's being cut off, because the members of Congress care about pork going to their district, an opportunity to go to the secretary of the White House and say, you can't bleep and do this because it's going to be very devastating. And there's an express provision in the statute for judicial review. So there's lots of procedural reasons in the statute why. It's just the juice is not worth the squeeze for an agency to try to take away federal funds from a violator of these statutes. And there are lots of reasons why they wouldn't want to anyway. If you think about who's taking away federal funds, it's the Department of Education taking away educational funds from universities, the Department of Health and Human Services taking away research funds from researchers at universities. Well, if they care about the public purpose of the funding program, if they care about financing people's education, financing medical research, they're not going to want to cut that off because somebody discriminated. I mean, that would be injuring innocent people instead of going after the violators. And Senator Humphrey himself, in the debates over Title VI, said this. He said, the remedy is a last resort to be used only if all else fails. And why is that? Because cutoffs of federal funds would defeat important objectives of federal legislation without commensurate gains in eliminating racial discrimination or segregation. But it's even worse than that, because courts, and I won't go through this now just for time reasons, but again, read the paper. Courts have used the fact that there is a funding termination remedy for Title VI and Title IX and Section 504 and Section 1557 to dramatically limit the ability of private parties who are injured by discrimination, victims of discrimination themselves, to bring their own lawsuits to effectuate the requirements of those statutes. So we have a funding termination remedy set forth in the statute that is not, in fact, the sword of Damocles. It is significantly limited by statute. There are lots of reasons why a conscientious administrator would not want to use it, and nonetheless, it has been used, its existence, its formal existence, has been used by courts to justify dramatically reducing the private right of action to enforce those statutes by the victims of discrimination themselves. Now, some civil rights advocates in the past have said, look, the problem here is that enforcers of civil rights in the government just haven't had the courage of their convictions. They haven't had the gumption. They should be cutting off funds more often. They should go through these very complicated procedural requirements, because that will send an important deterrent message. And people in the civil rights community have said that at various times. And my former student and now law school colleague, she teaches at Georgetown, Eloise Pasikoff, has written a terrific article making this argument. I will say the last few months demonstrates that that call would be a mistake. The Trump administration, for the first time, has used the funding cutoff tool in a very significant way, and it's done so extremely aggressively, not to enforce civil rights, but to target political opponents, cutting off $400 million from Columbia until they agreed to a set of demands that went well beyond any plausible violation and that intruded on their academic autonomy and academic freedom in significant ways. Cutting off $2.7 billion from Harvard is leverage to make even more extensive demands, which provoked Harvard to file a lawsuit. As of now, Harvard has prevailed in the district court, but we know what happens to district court decisions against the Trump administration these days. Cutting off $1 billion from Cornell, $790 million from Northwestern, over $500 million each from UCLA and Brown, and a mere $175 million from Penn, on the basis of, again, allegations that would not be sufficient to establish a violation of the underlying civil rights statutes under accepted standards. Some of these institutions have decided to give in, Brown and Penn. Others are continuing to negotiate and may litigate. I think about UCLA, Northwestern, Cornell in that category. The Trump administration has used the threat of funding cutoffs to make threats against UVA, forcing them to depose their president, and against George Mason University, which has stood strong. But this is continuing. Notably, these fund cutoffs and threatened fund cutoffs do not comply with the statute. They don't follow statutory procedures. Remember, there are all these procedures. The administration didn't go through any of them. They don't respond to plausible violations of the law. Happy to talk about that. And they don't at all comply with the pinpoint provision. They cut off all funds to Columbia or to Harvard or to these other institutions on the basis of alleged violations that did not occur across the entire institution. These actions are pure bullying, and they're part of a pattern of attacks on independent civil society organizations, which is now being empowered by this tool. Now, a lot of my friends who are left of center activists would say something like, well, sure, Trump's using these powers in an abusive way, and it's just yet another example of how the Republicans are willing to use the tools they have, and the namby-pamby centrist liberals who occupy the power in the Democratic Party are not willing to do it. So let's take a page from the Trump playbook the next time we're in office, and let's use this. I am, in general, sympathetic to the position that Democrats, liberals, people to the left of liberals should not unilaterally disarm. But I don't think that argument works here. The abuses we've seen in the past few months aren't about Trump having the gumption that liberals didn't. They're about a fundamental problem with the funding termination mechanism. And that problem is that the fund termination mechanism ties effective enforcement of civil rights to important public purposes that are served by federal funding. If you care about the public purposes served by federal funding, you are necessarily going to be wary of taking away your effectuation of those purposes in order to serve civil rights. You are faced with an impossible choice if that is your remedy. What Trump shows is that the termination mechanism will effectively be available only when the people who are administering the civil rights enforcement edifice don't care about or are affirmatively hostile to the public purposes served by the spending programs, right? I mean, it's not a surprise that the same administration that is cutting off all funds to Harvard and to Columbia for medical research is also just dramatically cutting medical research funds, right? Those are ideologically aligned. Now, I have some suggestions, which if you read the paper about the solutions here, I think we can continue to tie the substantive requirements of these civil rights laws to the receipt of federal funds. I think that has certain value, both in terms of the normative value articulated by Hubert Humphrey back in 1964 and in terms of overcoming state sovereign immunity. But I don't think we need to have the funding termination remedy. In fact, I think the funding termination remedy on net is bad for the world, and we should get rid of it and replace it with an appropriately tailored set of individually focused remedies. And thank you very much. I look forward to your questions.
Right. Thank you all. I'm so thrilled to be on this panel with these amazing scholars. Thanks for putting me last. And I mean that, though, because I think my talk actually has some amazing connections with almost everything that we've heard so far today. So hopefully this is a nice way to draw some of the threads together. So this is the story of a pair of emails that I received in my role as a faculty member in February.
You can close the mic.
Of course. I have a podcast, but I'm not good at it. So this is a pair of emails I received as a faculty member in February of 2025. I started my career as a high school English teacher, so obviously I'm going to bring in Charles Dickens. So he opens his classic A Tale of Two Cities with the paradoxical line, "It was the best of times, it was the worst of times." So he's talking about a moment of contradictions when freedom and repression coexisted, when institutions were under siege yet struggled to endure. I want to borrow that framing, but maybe not on such grand terms, because this is, after all, just a tale of two emails. So our first email was in response to an executive order that we've already talked about, signed by Donald Trump in January of 2025. That order, which was the first of many of its kind, directed the federal government to take immediate steps to end federal implementation of, quote, unlawful and radical DEI ideology. The order itself didn't seek to define these terms, as we've talked about, nor did it go into detail about how to accomplish this goal. That, importantly, was left to others, like my institution. The second email addressed a notice from the National Institute of Health that indicated that NIH would be capping indirect costs at 15%. Now, for those of you who haven't felt the academic pressure to go out and get grant funding, indirect costs are things like facilities, equipment, administrative support, basically everything that you're not going to put as a line item on a particular grant, but that your institution spends money on to support the work. So to put this change into context, U.S. negotiated rate is 52.5%. I'm no mathematician, again, I was an English teacher. That feels higher than 15%. And when applied to the over $250 million in NIH grant funding that UF received in 2024, we're talking about a decent chunk of money, or at least a massive administrative burden to align the indirect rates with the new expectations. So my institution, faced with these executive actions, had to decide how to respond. Enter our two emails. This is the first email that I received from our Vice President for Research to the faculty on February 5th. It says that, quote, as a result of the executive order, we should immediately halt all grants or contracts that use or promote the use of DEIA principles and frameworks or that violate federal anti-discrimination laws. Now, this email is interesting for any number of reasons. I'd like to just highlight two. First, I find the use of the word "or" incredibly interesting. Because that "or" recognizes that there are DEI activities that are not a violation of federal civil rights law. And that's something that we've seen a lot of these orders do, and a lot of this stuff coming from the Trump administration, is they equate unlawful DEI with DEI practices. They use a lot of linguistic maneuvers to basically create those as synonyms. The second thing that I want to identify is just the phrasing of DEIA principles and frameworks. Now, we've already talked about kind of the ambiguity of language and the importance of words. For me in my work, And the way I understand my concept of justice, equality and equity is a major part of how I conceptualize justice. And all of my work as a school law scholar is about justice in some way or another. So does that mean that my work, as attenuated it is under DEIA principles? I also do a lot of special education work, which the A is accessibility, the I is inclusion, is my special education work, and the classes that I teach, does that fall under this as well? This email and the executive order do not answer those questions. Instead, that is now left up to me as the individual to figure out where those lines are. So 5 days after I got this email, I got another email. This one was slightly different. Rather than direct us to comply with the NIH rate changes, we were told to ignore them. We were told to take no action to make any changes because our administration expected legal challenges and hoped that NIH could be convinced to change their approach. 2 emails. Both reflect executive attempts to change the terms of already awarded grants. On their face, these actions are very similar. Yet, my institution's responses were vastly different. Strict and immediate compliance in one case, open resistance in the other. Like the London and Paris of A Tale of Two Cities, these emails reveal a potential paradox. Why did UF respond so differently to similar actions from the second Trump administration, and what implications does this have for the legal and practical limits of executive authority in higher education? As one of my law professors at the Ohio State University would say, you never know what the rules are until you know the rules about following the rules. To understand these rules about the rules, we need to attend to legal doctrine as well as the political economy of higher education. When I say political economy, I mean the broader system where politics, economics, and institutions interact. It's about how power, money, people, and rules shape each other. Law is a part of that, of course, but the key point is that universities don't just read the Constitution and act. They respond inside these larger systems, weighing legal risk alongside political pressure, financial stakes, and their educational values. This is the process by which the law is translated from words on a page into lived reality. So how should we understand the current political economy of higher education? Well, as we talked about, and as is kind of a theme of a lot of our talks today, these 2 emails are responses to pieces of a larger ideological assault on higher education by the Trump administration. Officials in the administration have openly described their goal as disrupting higher education and breaking what they see as liberal orthodoxy. The mechanisms and justifications of these efforts are wide-ranging. Many of these efforts have been justified as necessary to address anti-Semitism, to address impermissible racial discrimination through DEI programs, and remember back in the early days of the Trump administration, with DOGE, the efficient and accountable use of public funds. All of those have been used as shifting justifications for these larger actions. The mechanisms, though, to accomplish these goals, the administration has engaged in a full court press of higher education. One strategy has been to stop the flow of money. The Trump administration has disrupted existing grants in the billions of dollars, halted payments, sought to terminate and not award new grants that don't align with the president's preferred viewpoints or policies. We at UF received a list, and I think this has been published elsewhere, of like the words not to use in new grant proposals, going back to what Professor Kolker was talking about with scraping stuff from the websites. And this has led to substantial financial uncertainty for colleges and universities and their faculty. Our tenure and promotion, in many ways, relies on the grants that we bring in and the work that we do with those. So, relatedly to all of this is the threats to stop federal funding, as we just heard about under Title VI and these other civil rights laws. And connected to that, the administration has leveraged existing rights enforcement to put pressure on institutions of higher education. So by May of 2025, the U.S. Department of Education's Office for Civil Rights had launched over 80 new investigations directed by the Trump administration, dealing with DEI-related discrimination, transgender student policies, and anti-Semitism. And these new investigations were opened despite OCR losing approximately 40% of its staff in massive layoffs at the Department of Education that saw 7 of the 12 OCR offices closed. So we have fewer staff and this wave of new investigations. Those investigations were never done quickly, but these were. So historically, the process of these investigations themselves has been the punishment because the enforcement mechanism was a gun too big to fire. So resolving these required extensive investigation time, resources to resolve. They almost always ended up in resolution agreements, but the Trump administration has shown a willingness to use these to threaten, and without following appropriate process, threaten the federal funding for these different institutions who have come under their scrutiny. Now there's other levers too beyond just the money. The Trump administration has also used some novel mechanisms as well. It sought to use its authority over immigration to block colleges and universities from enrolling international students and employing international faculty. The president has threatened schools' tax-exempt status with the IRS, which would have profound implications for tax burdens as well as their philanthropic support. If you can't donate money and write it off for your taxes, there goes one of the primary mechanisms that colleges and universities use to get philanthropic support. The administration has threatened to add new taxes to the university's endowments, has placed caps on some students' federal aid, and it's also sought to leverage accreditation as another potential fulcrum. In April, President Trump issued an executive order that instructed the Secretary of Education to focus greater scrutiny on higher education accreditors. These are the people that basically give stamp of approvals for colleges and universities to, assess kind of quality and that they're meeting certain academic standards. The order stated that these accreditors needed to focus on eliminating DEI and promoting, quote, intellectual diversity. The irony of those two things next to each other I don't think is addressed in the order. But going a step further, HHS and DOE have recently informed the accreditors of both Columbia and Harvard that they may no longer meet accreditation standards due to findings by the Trump administration that they are in violation of federal civil rights law. So yeah, decrediting Harvard and Columbia would be a pretty big deal. So rather than understanding or addressing these actions individually, these efforts all inform the political economy of what universities are navigating. Also relevant to these legal actions are the legal, political, financial, and educational risks that universities have to weigh as they chart a course through these uncertain waters. So in terms of legal risk, the question is beyond whether or not an action is lawful or not. These risks go beyond the merits. Universities have to consider the cost of legal action, the likelihood of legal action, how long it's going to last, how resource intensive it's going to be, what the political fallout is going to be, and ultimately the probability and significance of any potential finding against or for them. Further complicating these considerations, though, are questions about the current treatment of precedent and the ideological makeup of the courts. Thus, while universities have strong legal arguments to challenge many of these actions on spending clause, First Amendment, or procedural grounds, as demonstrated by Harvard's success at the district court level to unblock $2 billion worth of funding, the strengths of their arguments is only one part of one piece of their deliberation. Also weighing heavily on public education institutions are the politics at play here. And I think we're all probably very familiar with just how complicated the political situation has become. Public trust in higher education has been declining for decades, with growing partisan divides. Add to this a volatile and polarized political environment, and institutions aren't able to please everyone, sometimes playing it safe and staying out of the spotlight and off the agenda is the safest play. Financially, the risks are potentially catastrophic. Losing all of your federal funds would likely be a death blow to many colleges and universities. Balance this against the costs of settlement and the costs administratively and financially of prolonged litigation. Also of concern, though, are impacts of state funding and philanthropic support, depending on the politics of how all of this shakes out. Many of our state institutions rely heavily on state funds, and those states are, in many situations, ideologically different than perhaps the institutions they're funding. Finally, and from where I'm sitting as a former English teacher and a school law scholar, and most importantly, is the educational risks. The Supreme Court has recently, repeatedly, emphasized that colleges and universities serve the public and play a crucial role in the pursuit of truth and the preservation of democracy. And higher education institutions see themselves advancing those same missions. So this is a word cloud, because who doesn't love a good visual, of 300 college and university mottos. So I put them all into this word cloud, and these are the words that show up the most. 3 themes jumped out to me. And I'd love to hear what you think too. Seek truth, serve others, cultivate character. I think that covers a lot of what is on there. And these educational goals are at the forefront of institutional decision making, and as institutions navigate this political environment and the various risks, they also consider the potential impact on their educational goals. So how has this political economy been playing out? How does it help us better understand the scope of executive authority over higher education? So we've talked about Harvard, Columbia, Brown, University of Pennsylvania. They provide some useful case studies. They've all found themselves at the scrutiny of the Trump administration. And for Columbia, Brown, and Penn, they've all entered into agreements with the federal government to avoid, hopefully, additional scrutiny from the Trump administration. So Columbia entered into a $221 million agreement, Brown a $50 million agreement. Both of those included policy concessions related to the use of diversity statements in admission and hiring, transgender student policies, which was also the subject of Penn, which didn't have a dollar sign attached to it, and campus climate related to particularly the treatment of Jewish individuals on campus. Compare these responses, though, to Harvard and now UCLA, who have proactively brought lawsuits challenging the Trump administration's actions. So far, Harvard's been successful in challenging efforts to limit the enrollment of international students and freezing the $2 billion, the $2 billion in grant funding. And similar situations are unfolding across the country now at least a dozen institutions who have been targeted by the Trump administration, including Princeton, Cornell, Northwestern, Duke, UCLA. And as each of these targeted universities navigate these assaults, they have to balance the legal, political, financial, and educational risks. And depending on their context, their mission, their tolerance for risk, and how they prioritize those values and risks, we've seen institutions charting very different paths forward. But what does this mean for colleges and universities that haven't been explicitly singled out, like my institution, the University of Florida? Our tale of 2 emails tells a very, very similar story as the one playing out at the institutional level. Within institutions, administrators are weighing the same considerations. Given the political context in Florida, we're probably about 2 years ahead of everyone else on the anti-DEI stuff. So I don't know if that's a good thing. I've got more experience, I guess. Responding in any other way to that first email was politically infeasible. There was just, or at least very risky. Given the political climate in Florida, there was no other way for the institution to respond. For the second email, the severe financial risks outweighed the slim possibility that this requirement would go into effect and would be implemented and enforced. So by exploring how institutions and administrators navigate the current political economy of higher education, we can understand and inform the varied responses to the Trump administration's efforts to remake higher education. These responses vary from what I call aversive hypercompliance, namely adopting risk-adverse interpretations to avoid legal scrutiny before you ever become under the microscope, like you have to do with our first email, to active resistance, like in the case of Harvard and their proactive lawsuits. Interestingly, a more subtle form of resistance that has grown out of this is that universities targeted by the Trump administration have nearly doubled their spending on lobbying this year. potentially trying to get ahead of some of those political risks. So integrating law and the political economy of higher education also demonstrates the limits of legal doctrine. Formal doctrine constrains the executive on paper, and perhaps after years of litigation by willing colleges and universities by the courts. But the political economy shapes the law's reach in practice. We know that these actions are having a chilling effect on institutions, their faculty, and their students. A recent report from FIRE found that over 1/3 of faculty had recently toned down their writing, and that a sizable number felt that they were unable to speak freely for the threat of punishment or other consequences. And emerging research is bearing this out, both in Florida and across the country. So through its efforts and the current political economy of higher education, the Trump administration is accomplishing indirectly what the First Amendment forbids directly. So returning to Charles Dickens, he wrote of Revolutionary Paris that, quote, "It was the age of wisdom, it was the age of foolishness, it was the season of light, it was the season of darkness." Higher education stands at a similar crossroads. Our two emails crystallize this paradox. And to put it into Dickensian terms, it is now the age of compliance, it was the age of resistance. So both of these emails were in response to actions that tested the limits of executive authority. And they revealed that these limits are mediated by legal doctrine, but more immediately by institutional discretion shaped by the political economy of higher education. Ultimately, the future of academic freedom won't be decided only in the courts. It will also be decided in inboxes, conference rooms, faculty meetings, classrooms, and on social media, in the everyday yet significant choices that institutions, faculty, and students make about whether and how to comply or resist. And that's our tale of two emails.
Thank you very much for the panel. I think we have, 10 minutes for questions?
I think until quarter after, or I guess we have wrap up. I don't know that there's much to say with wrap up, but.
Okay, so more than 10 minutes.
Yeah, let's say 15.
Okay.
One question. Oh, sure. One question is about, and I was struck by the earlier panel when Ruth Kolker talked about the immediacy with which Ohio State kind of scrubbed everything. Although I'm sympathetic with the views of the folks on this panel, I also thought there was virtue in having George Dent kind of mix it up. And so I want to ask a question that might mix it up a little bit to get your reaction. And that is, I wonder whether there there seems to me to be sort of this possibility that the reason all of the attacks are going to the types of exercise of power and the remedial impact of what the Trump administration has done, and I understand that, but I wonder why we haven't seen a full-throated defense of the following proposition, that the DEI initiatives and programs of the majority of colleges could in no way, upon scrutiny, be deemed to be violative of the non-discrimination norms which the Trump administration is purporting to enforce, although most of us recognize that that's a little bit facetious. But I wonder whether there's something there that we're not seeing. In other words, Ohio State didn't immediately re-articulate or point out why it was in the right. They immediately scrubbed it. And that, I'll tell you what it tells me as someone who focused more on litigation than on academic life for the last 20 years, is that what would I paint that as in court? I would paint that as an acknowledgement that they had screwed up in some way. And so I wonder, is there a way in which we've sort of screwed up, even with our best intentions in our DEI programs, in some way that we can either refashion them, strengthen them to make them more impervious to this kind of attack in the future? So I ask it again. It's a mix-it-up question, but not in hopes of seeing DEI dead, but in hopes that maybe it gets reborn in a way that's a little more sustainable and impervious to attack.
Okay, I'll go first. That's good. You'll have forgotten my answer by the time other people talk. So first of all, there have been full-throated defenses. I mean, in response to the Dear Colleague letter that took these sort of, to me, implausible positions about what the law required, a number of law professors around the country, including myself, wrote a very long memo to general counsels around the country saying, this is totally wrong, and in fact, standard DEI practices are not a violation of the law. But I take your point that it's the institutions, haven't defended it, and I think from my perspective, there are a few things going on there. One is this sort of fear and risk assessment, that we heard Chris talk about. Another is, look, there are constituencies within university governing boards that never wanted to do this, that felt like they were bullied into doing this, that felt like the George Floyd protests and, even before then, the beginnings of the Black Lives Matter movement at the end of the Obama administration led to student pressure that they were caving into, but they never really liked it, and so they were looking for an opportunity to pull it back. I think there's also the fact that the way that some DEI programs were implemented, or some aspects of many DEI programs were implemented, while not plausibly unlawful in my view, were kind of not very useful, and were certainly perceived by people who had to undergo the programs as very annoying. And so there was not a lot of constituency for the programs. There was some, an important constituency and people very angry. At the University of Michigan, we weren't targeted in any way. Our university got rid of all its DEI programs too, right after the election. And they explained it as we're avoiding liability, we're keeping our heads down, we don't want to be on anybody's target list. But there have been a number of long articles in the New York Times about how everybody at the University of Michigan hates DEI. Well, it wasn't everybody. It was actually just the people who were complaining. But there were a lot of people who were complaining. And so I think it's complicated. But I like the way Chris tells the story in the sense of there are a lot of constituencies, and it's a very political process within the university as well. And that's certainly been my perception. But I don't think, there may be people who believe that DEI programs are unlawful. Certainly that's the view of the Trump administration. I don't think a lot of the institutional leaders thought that. I just think they were either afraid or were looking for an opportunity to get rid of them.
I'll be more of a hatchet man on that. To suggest that our evaluation has been a lot of times what there is a mix of DEI programs that are clearly lawful, and I think it's ridiculous that giving people lists of words to take down, etc. That doesn't even all that is just putting a band-aid. If the problem is that the DEI stuff is there, just taking black people off of cases website does not solve whatever the underlying problem of that was, right? So I think there's a mix of that, but there is also a lot of unlawful activity going on. Universities are big institutions. I think one of the most obvious places we see that is it's rare that you don't. There are plenty of faculty members who have stories about, particularly faculty searches, where there is effectively some sort of mandate that you are only allowed to have X number. So if you've got 4 people, 3 of them have to be underrepresented minorities, right? This is a form of racial preference that isn't legal unless it's being done as part of an effort to make up for specific incidents of past discrimination. But faculty members do not realize that. Like, the faculty members actually conducting the searches, that has not trickled down to them. And so this keeps happening, and you keep seeing these reports of this happen. And I suspect that a big part of the hammer that the Trump administration is using here is that they know that the universities know that if somebody really looks hard into what they're doing, there's somebody on campus who is breaking the law in a way that is unambiguously unlawful. And that is a really good hammer to use on the rest of the program, because you can use it to smear the entire effort. And there's enough clues left over in like the settlements they make with people particularly that I think that's part of their strategy.
So I want to push back on the question in the sense that the question that you ask is a subset of a bigger question. Where is the full-throated defense of living in what is for America, a very young multiracial democracy? So I think I come at this as, to pick up on what Sam said, right? There are some people who did not like having this to begin with. Some people who, in the leadership of higher education, who are calculating risk and reward, maybe some, senior university administrators and boards of trustees who felt backed into this, and some people who I would add to the list of possible characters there, some people who might have taken advantage of the political situation, not only to sort of avoid the problem that they might see in the particular electorate, but who do not want to live in a multiracial democracy. Period. Full stop. Right. I alluded in my talk to most people agree that, to put it very simply, racism is bad, but most is not all. Right. And in some ways we have political distortions that might let that minority have over exhaustive influence in society, who then might run the gamut of politics in order to create a space where certain people who also share those beliefs end up being in power and then using the mechanisms that we've just spent the last hour and a half talking about to go after things in this way. And so the deep premise is in need of defense. And mind you, maybe I pitched the next year's symposium right there, but there are dimensions to the claim that you're asking us to think about.
So I'm stuck back on the question that has been sort of dogging me all day, which is what's changed. It's very obvious to me that something has changed, even in the last 2 years since we had a symposium on this. And yet each of you in a way reminded us that what has changed is not the fact that the government is involved in making decisions about what can happen on college campuses. It's the very existence of Title VI and Title IX are decisions by the government about what can happen on college campuses. And they are very clearly anti-discrimination measures with potentially severe consequences, although, Sam, I think you point out that those consequences are severe in ways I hadn't thought about before, so thank you for that. Is what's happening now only different because it's sort of anti-reverse discrimination, whatever that means? And I think the presence of what I find to be perhaps disingenuous, but nonetheless loud discussion of anti-Semitism to maybe confound that. So sort of, is this the same thing, and the only thing that's changed is that it's anti-discrimination rather than just anti-discrimination? I think the answer is no. I think something else has changed. As Chris points out, it's very easy to throw the minority under the bus, and maybe that's why it feels so different. But what's your take on what's changed?
I think Sam sort of intimated of this, and it's something that I think I didn't manage to get across, and it was in my presentation, which is that I believe it is a conscious political decision on behalf of the administration that they no longer have a constituency that is worth protecting in the colleges and universities. The way I've seen this, and this is not a classy way to put it, but they feel like the hostages are all dead, right? Like the higher ed is already like, what are they going to do? Get rid of the last conservative professor? They already did that 10 years ago. So there's no more constituency. That's how, now, whether or not that's true, and of course it's not, of course it's not true, technically speaking, but it's close enough to being true that, that's why you see this opening. I think that's a big part of why you see this gap in confidence opening up, where I think the Trump 40, because Trump 45 did not do this. Same person, right? Many of the same people didn't do it. Some calculation changed, where they decided they no longer have a reason that they have to consider what damage they might do to higher ed. And you have to have, if they don't care, then you have a lot of freedom.
I would just say one other thing about that, which is I think you have to see what's going on with respect to anti-discrimination law enforcement in campuses in the context of a much broader set of actions that the Trump administration is taking, which are systematically deploying the power of the state in its most aggressive forms against either opponents of the administration or independent sources of power and authority. And so, look, we're talking during the week when Jimmy Kimmel was almost certainly fired. He's not been formally fired yet, but that seems to be pretty clearly where it's going. And the pretext was something he said about the person who shot Charlie Kirk, but then, Donald Trump gave away the ballgame saying, well, these people attack Trump all the time and they're not allowed to do that. Brendan Carr, the head of the FCC, had previously initiated investigations of many major news organizations for coverage that they believe to be unfair, the massive libel suits that are being brought against press organizations, but also the executive orders targeting law firms, are the same thing. The shutdown of federal funds to research, again, not when it's not explicitly tied to anti-discrimination, and on and on and on. There's just this whole set of actions that this administration has taken saying, if you are speaking in a way that we like, we'll continue to support you. And I noticed the head of the Ohio State University ran to Washington and said, we are going to be your friends on this, and that's the dynamic that they're trying to promote. But it's not, so I wouldn't. They're using tools that were used or were available to others in particular areas, but I think you have to look at the whole picture.
And now I'll add, at risk of the answer changing as it goes down the line, the coordinate branches of government have taken either little to no interventionary action, like Congress has remained all but silent in regards to a lot of these things, including power taken by the executive from Congress to redefine major statutes and other powers that were supposed to actually create tension, right? And that was the original constitutional design. And then a court that seems sometimes collaborative, sometimes sort of standing by, oftentimes willing to simply find justifications for things. I'm thinking back to Trump v. Anderson, and once we got this interpretation of Section 3 of the 14th Amendment, we see an imperial presidency becoming more and more imperial. So there is the context there as well.
Yeah, and so much of this, to me, raises questions about the rule of law and the relationship of what it is we all do in these spaces, right? And it seems like a lot of these shifts are moving away from a rule of law to a rule by law. rather than, because many of these actions are taken independent of their underlying lawfulness. And so I think it's a number of factors: declining trust in higher education, the perception of higher education institutions as being too liberal, the anti-intellectualism. We saw that in the vice president debate when J.D. Vance kept talking about common sense. And I think all of these things are just kind of coming together to create a perfect storm that is flooding the zone.
One last quick.
Yeah, just something I've been thinking about this whole time is I'd imagine if we had someone from Bob Jones University circa 40 years ago here, and I want to be clear, there's no love lost between me and Bob Jones University, right? But very famously, they had a policy that students couldn't be engaged in interracial dating or marriage, and their tax-exempt status was taken away by the IRS, and this was upheld by an 8-1 Supreme Court. And I'd imagine if we had someone from Bob Jones circa 40 years ago here, he would say that, hey, the government came after our free speech. They came after our sincere religious beliefs. Again, not my sincere religious beliefs, but they're admittedly, I think you'd have to assume sincere religious beliefs. And we can distinguish this conversation maybe on procedural grounds, Professor Bagetso. Sorry, I'm pronouncing your name, right, pointed out that there's procedural things the Trump administration's doing. Maybe the IRS followed the right procedural things there. But on purely First Amendment grounds, are there ways to distinguish this from what happened to Bob Jones? I don't know. I don't like racial discrimination, right? I don't like bans on interracial marriage or whatever like that. But it seems conceptually similar.
Yeah, they would certainly argue that it is conceptually similar. I mean, it is conceptually similar. Are there ways to distinguish them First Amendment-wise? Sure, there are. But if you were to bring them forward, they would be saying, "I told you so," and that this is what we were warning about. This is what happens with the government. I mean, I have my moments of sheer libertarianism where it's kind of like, well, this is what happens when the government gets too intertwined in everything, and there is some real merit to that.
I mean, all I can say is this was sort of the point that I was trying to get people to answer in the question I asked in the first session, which is, we are going to live in a world where, I mean, this is Charles Reich, the new property. It's not like a new point. We are going to live in a world where the government is financing lots of really important stuff we all do, and our personal and institutional livelihoods depend on it. And that's going to give the public a claim on things we do, but we also need to protect liberty. And where that line is actually a really complicated question. I am quite certain that if Bob Jones came before the Supreme Court today, as res nova, as opposed to, being on the books as stare decisis, then it would come out the opposite way. I mean, and honestly, all the people within the Reagan administration who flipped sides in that case, like John Roberts was there at the time, and that's the folks who Sam Alito was hanging out with, and those were folks who were significantly to the left of some of the Trump folks coming on now. So, but I think you can say no race discrimination ever. That's a nice way to distinguish it. On the other hand, I don't think that would satisfy the folks at Bob Jones University.
I'm going to quickly refer you back to my prior answer. Some people don't like to live in a multiracial democracy. And I'll also point out that in some ways, I get the First Amendment framing, but at the same time, the Constitution didn't stop with the Bill of Rights. Right. And so there is a 14th Amendment, a 15th Amendment that raise complicated questions, amendments designed to promote multiracial democracy. And so if those people came here today, my question back to them would be, how would you accommodate that, especially if it were like a textualist or originalist kind of conversation we would have?
I have the benefit of having my slides up. For me, I always go back to what is it we're doing as institutions of higher education, right? We're serving the public. And so to the extent we can go back to those kind of public service goals and align our actions and the lines we have to draw about state authority and what we do, and the more we can do to kind of articulate how our actions align with those goals, I think like maybe that gives us hopefully a useful framework to think through how to navigate these complicated issues in different contexts.
Right. I want to thank the panel one more time for the fascinating conversation. Closing remarks, like it says on the agenda.
Would you like to mark?
I will make a couple of closing remarks, very briefly. So the main closing remarks I want to make are thank you so much to the panelists, to Maggie, to Fatima, who is ill today, but is watching online, I hear, to all the faculty members who could make it, to everyone who's watching online. This was a great event, and I think a thought-provoking one. I hope we can all go home and keep thinking about these questions. I look forward to publishing about them. And if the speakers who are still here could gather for a photo, there aren't very many of you left, but it would be really great to get a photo of at least a few of you. And have a great evening, all. Thank you.